And we are, as a reminder, in the throes of our license law and commission rule comments. Specifically, the comments that we're looking at are in the online learning system. Good morning. In the online learning system under the under license law and commission rule, and then you can find the comments located there. So that's what the main focus of this discussion is. As I mentioned the other day, once we get through the comments, then we need to go back through some license law and commission rule and pick up a few other things. And primarily that's about like your license status and how do you keep it active once you get it, kind of important stuff, right? So not just testable material, but also to help you in your career. So good morning. So we are, again, moving right along. And for those of you keeping up with the comments, we're going to start out on page 13. And we are going to talk about, maybe, brokers as parties to the transaction. So remember we said the other day, once you guys are licensed, you're held to a higher standard. And that does include when you are buying or selling property that you own or you have a personal interest in. So if you're buying property for yourself, or if you're selling property that you own or that you have an ownership interest in, you're going to be held to a higher standard. Even though you may be acting as a seller, you're a licensed seller. So the presumption is that you know more than the unlicensed buyer. Does this make sense? So that's why you're being held to a higher standard when you're acting on your own. Specifically, the commission rule says that when you're selling a property that you own, you are the owner of record. You cannot represent the buyer in this transaction. Can we see a huge conflict of interest? Buyer hires you to help them buy a property that you own. You now owe that buyer old car. You own the property. Who should your loyalty to? Your loyalty, your old car should be to that buyer that hired you. But let's face it, y'all, if your name's on the deed, who do you really care about? So do we see the conflict of interest? So when you are selling property that you own, you can't represent the buyer in that transaction. Another agent in your firm could, but you cannot. You, the individual, cannot. If you want to sell, if you want to buy a property, that you're acting as the listing agent. So you're listing a property for sale, you're going through the home, you're learning about it. This happens, you guys, by the way. You're going through and you learn about it, you say, my goodness, this is a cute little house, I want it so bad. Again, you cannot proceed as the listing agent. You need to get with your BIC, they may want to reassign it. But you just need to take that conflict of interest in mind. I'm in the license law and commission rule comments under license law and commission rule folder in the online learning system, and we're on page 13 of the comments. All good rules have an exception. This one's no different. If you are listing a commercial property that you have less than a 25% interest. Everybody hear me? You're listing a commercial property and you have less than a 25% ownership interest. You may be able to represent that buyer in the transaction as long as you go into a full disclosure. You've got to tell that buyer, I own a 20% interest. My name is on the deed. If you're okay with that, then I can represent you in the transaction. So that would be the only exception. Residential, absolutely not. Good morning. The Real Estate Commission also addresses if we ever change our name or our address. If you get married and change your name, if you get divorced and change your name. If you move, maybe you change firms, maybe you move your physical address, your home address. We need to notify the commission of name of our contact information, change of our contact information within 10 days of that change. So if you change your name, if you change your address, by the way, once you guys get your license, when you go to ncrec.gov, there's a button that says licensee log on. So you'll have access into like the back end of the commission's website, but that allows you to access your files. You can log on and change your name, change your address, change your contact information there. So 10 days to notify of a change of name or address, email, phone number, etc. When we renew our licenses each year, which we're getting ready to talk about, when we renew our licenses, they also ask us, but again, the commission rule says 10 days. There's commission rules on our advertising. So as we've been saying, you guys, I cannot work with an owner of a property, may that be for sale or for rent, without having written consent. And written consent comes in the form of our written agency, our written listing agreement, or property management agreement, whichever. I cannot advertise, I cannot do a single thing for an owner without having that agency agreement signed. So our advertising rules enforce that. We need written consent to advertise somebody's home for sale or for rent. Doesn't that just kind of make sense? So we need their written consent. And also the BIC is responsible for all the advertising that comes out of the office. So advertising of listings, advertising for brokerage service. The BIC is responsible for those advertisings. You know, one thing we've been saying is that the BIC is responsible for everything that the provisional broker does. Everything. I think it's safe to say that if the provisional broker gets themselves in trouble with the real estate commission, they're going to take their BIC down with them. As a full broker, the BIC isn't as much in our back pocket. But as a full broker, the BIC does have some responsibilities, one of those being the advertising. So we need to make sure that we have our BIC review the advertising before it goes out. Y'all know how social media and the internet works, right? Once you hit submit, what happens to it? It's out there. There ain't no getting it back, is there? So that's why we want them to review before publish. They're looking for things, as we mentioned the other day, they're looking for things to make sure we don't have any fair housing violations, all those words that HUD has flagged. The BIC is making sure also that we're properly advertising the brand's identity. Your firm has an identity. Your firm logo will look a certain way, and there's only a certain, colors that you can use for your logo, right? So the BIC's going to want to make sure that you're keeping up with the brand identity. The best example I can give you guys of brand identity are those golden arches. We can see those things from a couple miles away and know we got McDonald's coming up soon, right? That's their brand identity. And that's what the BIC is looking for. For example, my logo of my real estate firm, my sales firm, is blue and white, but it's not just any shade of blue. It's a specific shade of blue. And that's what keeps us recognizing brand identity. So just several things that the BIC is looking for when they're reviewing advertising. You guys think you're going to document your ads? Yeah. So, if you're going to do a social media ad, I want to take a quick screenshot of that so you have that documentation. If you're going to do a publication by the paper, so you have a copy of that. You guys with me? Because if the seller ever comes back and says they never advertised my property, don't you want proof that you did? So advertising is definitely documentation, for example. Specifically about advertising, one thing that the commission rule says is that in our ads, we can never have a blind ad. A blind ad is one that doesn't include the name of the firm. Remember, whose listing is it? Is it yours, the individual agent? No, it is the firm. So blind ad must include the name of the firm. I'm sorry, an ad must include the name of the firm. Blind ad would not. And guys, sometimes some agents might try to argue, well, the firm's name is in my email address. So if I put my email address in the ad, will it work? So if my email were like julie@caldwellbanker.com, Caldwell Banker is right there. Isn't that advertising? The commission says, no, that's not sufficient. We actually need to say Julie with Caldwell Banker house for sale, et cetera, et cetera. Guys, this does apply to social media as well. Social media is huge right now. If we wanted to, which we're not going to, but if we wanted to, we could spend all day debating about whether or not you should have a personal or a business Facebook page or a personal or business social media platform. We're not getting into that debate. That's something for you guys to discuss and consider later once you get going in your careers. But just note, if you choose to go the personal route, make sure those personal ads for listings or brokerage services include the name of your firm. Can I answer that later, please? That's a little off topic, so I'll address that later. Thank you. So advertising, no blind ads. Another commission rule that we've actually already met. We have a duty to deliver all instruments to customers and clients. We have a duty to deliver within 3 days of execution. Execution means that the document has been signed. It's been executed. Let's talk about what an instrument is. An instrument is just any document related to this transaction. So ideally, in a quick scenario, it's going to start with our agency agreements. We're going to have our agency disclosure, our agency agreements. Once you get all that signed, we have 3 days to deliver a copy to the client. We eventually go under contract. Once all that contract paperwork is signed, we have 3 days to deliver it to the client. And then the next big step, obviously, is closing. Once it closes, we have 3 days to deliver those documents. An instrument is just any document related to this transaction. I think a general rule of thumb, and I think you guys will agree with me on this, if the consumer signs it, don't they deserve a copy of it? So if your consumer signs something, client or customer, we have 3 days. And y'all, it's as simple as sending an email with a PDF attachment. Here's our copy of our agency agreement. I look forward to working with you. Have a nice day. Did that take you 3 days to send? I don't think so. By the way, do you think you should document the sent email, proving that you sent it? Yeah, because what do we document? Literally everything. There's no exceptions to that rule. So we're going to make sure, what if, let's say your buyer's agent, your buyer makes an offer, your buyer signs that offer, right? They sign it before they present it to the seller. Your buyer makes an offer, seller looks at it and rejects it within 30 seconds. Did the buyer sign that offer? Even though it was never accepted, they signed it, right? Don't they deserve a copy of it? So again, just kind of that general rule of thumb says if they sign it, they deserve a copy of it. And make sure you document that you sent it. Please also note this says delivery. That's my job, is to send it to them, to get it in their hands. Email was just an example. If you want to hand it to them, if you want to drop it in snail mail, doesn't matter how you get it to them. What they do with it when they get it, that's on them. My job is just to deliver it. My job is just to get it to them. The exception to the delivery within 3 days, the exception is when you are presenting an offer to a seller. If you're acting as the listing agent and you're presenting an offer to a seller, we have a duty to deliver those offers immediately, but in no event later than 3 days. So 3 days is still the max. Retention of records. Commission rule says we got to keep everything. So we're documenting everything. So let's keep everything for 3 years from the successful or unsuccessful conclusion of the transaction. If it goes to closing, then closing would start the 3-year mark. If it terminates, that would start the 3-year clock. So whenever the transaction is officially over, whether it closed or not, if there's still something that needs to be done, then the transaction's not over yet. It's the very last act, and that's when our 3-year clock starts. Again, some things that we're going to keep. What are we going to retain? Well, I mean, everything, right? But specifically, obviously, all of our paperwork, agency agreements, contracts, offers that never get accepted. We just mentioned advertising. You want to make sure you document all your advertising, keep that for 3 years. If you measure your own property, you measure your own listings, I should say, you want to keep those measuring sketches, your work showing that you did it. And guys, those measuring sketches, it's like cat scratch, and you're going to be the only one to be able to interpret it, but it still shows that you did the work. Does that make sense? It shows that you went out, you measured the home. Anytime you do a CMA for a buyer or seller, you want to document that, retain that, I should say. Emails, text messages. There's several different apps that you can download on your phone that will allow you to convert a text message to an email. And it gives you date, time stamps. So make yourself a note. Please don't do it now, but make yourself a note to go to your app store or your Play Store, and you can find a text to email. So you can have those documentations as well. Anything of substance about this transaction, we need to document. We got to keep it for 3 years. Technology is catching up with this rule. My firm uses a program called .loop, and that's where we do all of our e-signatures and store our records and everything. And just by default, .loop keeps everything for 10 years. So we are well in compliance with the Commission Rule 3. Disclosing of our brokerage fees and compensation. Both of our agency agreements, listing agency and buyer's agency agreement, say that if we are going to make more than the agreed upon commission, agreed upon in the agency agreement, if we're going to make anything more than that, then we have a duty to disclose that commission to our principal, to our client. And we have a duty to disclose that in a full and timely manner. Understand, a full and timely manner is not sitting at the closing table saying, as soon as you sign this paperwork, I get a $500 bonus. That's not a full and timely manner. Full and timely manner is to provide them with that information before they present the offer, so they have everything to take into consideration going into that transaction. So let's say, for example, the builder is offering the buyer's agent a $500 bonus. Guys, we've got to disclose that to our buyer client because we stand to make more than the agreed upon commission amount. So when they're thinking about making the offer, we say, by the by, this is what the builder's offered me. Let's talk about why for a second. Y'all put your pencils down and just think with me for 1 second. Seller sets the sales price, right? And we know that the commission is based off of the sales price. We say that the seller pays the commission off the sales price, right? Who pays the sales price? Who pays the sales price? The buyer. The buyer pays the sales price. So if you're getting a $500 bonus by the seller, does it stand to reason that that $500 is built into the sales price? So why does the buyer care? Because ultimately, at the end of the day, who's paying that bonus? So that's why we need to disclose it. That's why we need to let them know. And I won't get into that kind of detail, but you guys are with me, right? It's their money that we're dealing with. And that's why they have a right to know. Remember, our agency agreements already said, this is how much I expect to get paid if you buy a house. So if you're going to get paid more than that, then they have a right to know. When it comes to our commission, all we have to disclose is what the firm is going to collect, what the side is going to collect. My split with the firm is nobody's business. I don't have to tell anybody what my split is, but we do advertise what the firm expects or what the firm collects, and if the firm is going to collect a bonus. That $500 bonus has to run through the firm. They cannot hand that money directly to you. Because remember, we learned on Tuesday that we can only be paid by our supervising BICs, by our supervising firms. So whether or not you're going to get all $500 of that bonus, or you're going to get a percentage of that $500 bonus, is all up to your firm's policy. But it must run through the firm. And we don't have to share with anybody how much of that bonus we expect to collect, or the commission at all, what my split is. And then remember, we've said this a few times, so the real estate commission doesn't get involved with commission. That's one easy way to remember it. Commission doesn't get involved with commission, fees, referral fees, commission splits. They're not going to get involved with matters of your money. So if you're not happy with the commission split you're receiving from your firm, don't call the real estate commission. There's nothing they can do for you. If you're not happy with that split, find a new firm. You're an independent contractor. Just make sure you know what happens when you leave. It's funny to say that, you guys, but when you're signing that brand new independent contractor agreement, you need to read that thing, because you need to see what happens if you leave. Also, under fees and compensation, another thing we've been saying is that we're properly compensating our unlicensed persons. Unlicensed employees can only be paid hourly or salary. Unlicensed employees cannot be paid per transaction. They cannot be paid a commission. They cannot be paid a referral fee. They are hourly or salary only. And remember, when it comes to receiving any kind of bonus or kickback or referral fee, etc., RESPA rules. RESPA says real estate or settlement service providers can't give or receive compensation for recommending services. So if RESPA is involved, it's because the lender's involved. RESPA is a lender rule. And settlement service providers can't give or receive bonuses or referrals for recommending services. Any questions on commission? Disclose, disclose, disclose. By the way, if it's a cash buyer, RESPA's not around, right? TRI's not around. So if it's a cash buyer, the commission's rules will still run in. And one thing they say is that we can't give or receive anything of nominal value. And they say nominal value is like $50. So even if it's a cash buyer, I guess the most gift you can receive is $49.99. Tuesday, we talked about the broker in charge. We talked about being BIC eligible and then becoming the designated broker in charge. So let's talk a little bit more about the BIC. If the firm is set up as a firm, then it must have a designated broker in charge. If the firm is set up as a firm, it also might have what's referred to as a qualifying broker. And you guys are going to learn more about qualifying brokers, or QBs, when you get into post-licensing. But if it's set up as a firm, it has to have a firm license, it has to have a qualifying broker, and it has to have a designated broker in charge. And not just a designated BIC for the firm. We need a BIC at each office location. So if you set your firm up and you're just one office location, you just need one designated BIC. When you expand and you start adding offices, you need to add designated broker in charges. So we need one designated BIC under each roof, one QB for the firm, qualifying broker for the firm, but we need a designated BIC under each roof. And the BIC can only supervise one office at a time. The BIC should not be out multiplying. And that takes us back to our, can only have, one must have one designated under each roof. Some agents choose to go out on their own and not create a firm. You can go out on your own as a sole proprietor. How many people at a sole proprietor? When you see the word sole, what's that mean to you? Just one. So sole proprietor means you're a one-man show and you haven't created a firm. There are some limitations to being a sole proprietor, though. If you want to be a sole proprietor, you do not have to have a BIC, unless if you want to maintain a trust account as a sole proprietor, you need a BIC. If you want to advertise your brokerage services in any way, that includes handing out business cards, social media. You cannot advertise your brokerage services as a sole proprietor without a designated broker in charge. I'm going to come back to that one in just a second. And also, because a sole proprietor is more than just one, if you plan to have more than you, then you need to create the firm and have a designated broker in charge. So who are the people that are sole proprietors? You can't have a trust account, you can't advertise your services, and it can only be you. The people that are sole proprietors, the people that go out on their own and don't create a firm and are sole proprietors without a BIC are, for example, retirees. They've been in the business for 30 some years, and now they're just going to collect referral fees. So if I retire, when I retire, an option might be for me to hand over my book of business to a brand new pre-licensing student. Isn't that something? You just got your license and I say, hey, here's my book of business. But guess what? Any business you get from my book of business, I get a referral fee. That's our agreement. My book of business does not come for free. Does this make sense? So because I'm just collecting referral fees, I'm not out advertising or promoting, I'm retired. Because I'm just collecting referral fees and I'm not advertising my broker services, that may be an example of who might be a sole proprietor. That's the tricky one, you guys, for a sole proprietor. As a sole proprietor, if you want to advertise your brokerage services, if you want to go out on social media and say, call me, or if you want to hand out a business card, you've got to create a firm and have a designated broker in charge. The general rule of thumb with a sole proprietor says your business comes from those who should reasonably know that you have a license. Who reasonably knows you have a license? Mom, dad, significant other. You guys with me? Can you be a BIC and a sole proprietor? Absolutely. But if you're doing any of these, you're a BIC of a sole proprietor of a firm. That's what we're saying. Sole proprietors don't have to have a firm. They don't have to have a designated BIC, as long as they're not going to have a trust account, advertise, or have anybody affiliated with them. I know this is a big question for a lot of you right now. I know a lot of you are ready to run out and start your firm. Simmer down, bear with me, remember those goals. But just know, make yourself a note, because when you do go out and start your firm, again, you're going to get more information on firms and how they're created and all that good stuff when you get to post licensing. But you're going to want to make sure when you are ready to create your firm, you go back and revisit those commission rules so that you know that you're creating it properly. So sole proprietors may also be referred to as sole practitioners. So you're a sole proprietor, you want to advertise your broker services. Well, now you have to have a firm. You have to have a designated BIC. To have a designated BIC, you first must become BIC eligible. How do you become BIC eligible? You have an active license. We saw this the other day, so you guys already have this in your notes. To become BIC eligible, you have an active license, not on provisional status. You got to have some experience. They say at least 2 years full-time or 4 years part-time within the last 5 years. So 2 years full-time or 4 years part-time within the last 5 years. I don't know how they determine full-time or part-time. And then you got to take a BIC course. These 3 things will make you BIC eligible. Once you are BIC eligible, then you are eligible to become the designated broker in charge. Just as a side note, FYI kind of thing, they do give full brokers that meet the first 2 requirements, active license, no PB, and some experience. They will allow full brokers with the first 2 requirements to become the designated broker in charge, but then they have like 6 months to take that 12-hour BIC course. So they may allow you to skip that. This would be like a case of emergency, right? like the office's designated broker doesn't show up for work, passes away or something, and we need to slip somebody in, they will allow you to become designated, but you got a small window to go in and complete that 12-hour BIC course, or you'll lose that BIC designation. But for our purposes, for right now, become BIC eligible. Once you're BIC eligible, you're positioned to become the designated broker in charge. Once you are BIC eligible, and I mean, a lot of agents become BIC eligible and never become the designated broker in charge. They may do it for their own knowledge, their own personal goals, various reasons, but they never become designated BIC. They never have interest in becoming designated broker in charge. So once you're BIC eligible, you need to maintain that BIC eligible status. All brokers have to renew their license each year. We will talk about that in just a second. And to be BIC eligible, you got to keep that license on active status. How do you keep it active? We're getting there. So we'll talk about how you renew each year and how you keep it active. Once you're BIC eligible, if for whatever reason you lose that eligible status, you don't renew or you don't maintain an active license, then you got to go back and take that 12-hour BIC course again if you want to become BIC eligible again. So if you lose that BIC eligible status, you just got to go back and retake the 12-hour course. Keep the license active. I don't care who you are, BIC, broker, provisional broker, keep the license active. Again, we're getting there. We will talk about that in just a second. Anybody want to be the BIC one day? Anybody want to be the boss? There we go. Commission rule, y'all may be sick and tired of hearing this, but you know what? There's a reason why we have to say this over and over and over and over and over and over again. We are not attorneys. Everybody say it with me. I am not an attorney. Do you know how many agents get themselves in trouble for trying to help? I think this bumps on our kind nature. Buyer seller asks a question. They ask us to do something. I'm a lot cheaper than an attorney. In some cases, I'm a lot faster than an attorney. But guys, we are not attorneys. So we cannot draft legally binding documents. I cannot add verbiage. I cannot delete verbiage that's already there. This is why the North Carolina Association of Realtors and the North Carolina Bar Association came together and created the forms that we are allowed to use on a day-to-day basis. The purpose of providing us with these pre-printed forms is to eliminate our temptation to draft. When you guys get your hands on the form file, there's like 400 or 500 forms that they provide, but it's everything: residential, commercial, property management, it's everything. So they give us plenty of opportunities. Our job is to fill in the blanks. And those blanks that we're filling in, we're doing it with a discussion with our clients: purchase price, due diligence, earnest money, even our agency agreements, any amendments or addenda. But as good as the form committee is, and as many forms are available to us, there's no way that they can think of every possible scenario. There's no way that they can think of every possible situation. Do you very well may come into your point in your career where you come across a situation where you don't have a form for that. And your only option is to have your client contact their attorney. We are not attorneys. My job says I can fill in the blank of the forms that are provided to me. In Unit 10, we met our standard offer to purchase and contract, Form 2T. The contract we met in Unit 10 is the most commonly used contract, but I think a problem topic, I think a common misconception is that that contract is the only contract we're allowed to use. And that's not true. We can use any form, any contract, as long as it was drafted by an attorney and it meets Commission Rule A.0112. Again, that rule is just there for reference. But that rule gives us like, I think it's 18 or 19 different provisions of things that must be included in the contract if a broker is going to use it. Obviously, all of our contracts from North Carolina Association of Realtors apply to Rule A.0112. But just know, please understand, we can use any contract, sales contract, as long as it meets the rule and it was drafted by an attorney. Back to our builders. It's not uncommon for builders to have their own contracts. As a buyer's agent, can we assist our buyer with completing the builder's contract? Sure, as long as it's drafted by an attorney and it meets this rule. Another commission rule, we touched on this the other day. We all know you got to have a criminal background report run to get your license. Once you are licensed, you are not off the hook. Once you're licensed, if you get yourself in trouble, you've got to report that to the commission within 60 days. I need you guys to note a couple things as you're writing everything down. This word says convicted. Does that say charged? If you've been charged of a crime, it says, everybody see that? Convicted. You don't have to report it until the gavel comes down and the judge says guilty. So if you're charged with a felony or a misdemeanor, don't call the commission just yet. Wait till you're convicted. And the other piece of this rule, we asked the other day if you guys have another occupational license, another professional license. So if you get yourself in trouble with your other professional license, you've got to report that to the commission as well within 60 days. Again, what are they going to do to you? I don't know. It's a case-by-case scenario. It's a case-by-case. They review each case. This is what I do know. When it comes to this rule, I tend to think of mama. Now, I don't know what kind of household you were raised in, but in my house, if I did something wrong, it was best that I fess up to mama now instead of let mama find out about it on her own. Anybody else in a similar home? Yeah. Think of the commission as mama. It's best that you tell the commission about it and let them deal with it, then let them find out on their own. Because if they find out on their own that you didn't report it within 60 days, you will face a disciplinary action because you violated that commission rule. Question comes in about DUIs. Yes, if you're convicted of a DUI, that should be reported. Are you going to lose your license? I don't know. But we've got to report it. A felony or a misdemeanor, whatever the judge calls a felony or a misdemeanor. Anybody thinking about getting licensed in anybody live close to another state, maybe Virginia or South Carolina, Tennessee? You guys thinking about getting, you're right there on the border. So once you get your license in North Carolina, you may want to get your license in another state. Go to that other state's real estate commission. I don't know about licensing in other states, so please don't ask me. So go to that state's real estate commission, find out how you can get licensed in that state. But once you get licensed in that state, let's say you get a Virginia real estate license. If you face disciplinary action from the Virginia Real Estate Commission, that's a professional license, you guys. And you've got to report that to the North Carolina Real Estate Commission. CPA, CNA, What are other professional license? All those initials. Any professional license must be reported if you get yourself in trouble. Questions on this rule? Again, it's one place the test likes to trick you. Not when you're charged, when you are convicted. Everybody see that? Commission rule also covers our residential property and owners association disclosure statement, also referred to as the RPODs, and our mineral and oil and gas disclosure statement, also referred to as the MOG. We talked about both the RPODs and the MOG in Unit 8. These are seller disclosures, which means the seller has to complete these forms. But here's the trick with these. Remember, caveat emptor. Does the seller actually have to disclose anything? Caveat emptor says, no, in North Carolina, no. So these are mandatory disclosures. I'm sorry, mandatory forms with optional disclosure. Mandatory forms with optional disclosures, which means the seller has to complete the form. But caveat emptor says that the seller doesn't have to disclose any information. They have the option on the RPOs to say no representation. If the seller fails to provide the form, the buyer could have a period of time, it's 3 days, to terminate their contract. And if they put up any earnest money or due diligence, they will get that money back. So there is a small window. And again, it's not because the buyer doesn't like how the seller completed the form. It's because the seller didn't provide the form. That's the seller's responsibility with this form, is to provide the disclosure. They do not have to disclose anything. Mandatory form with an optional disclosure. I think, Erica, that's allowed for the judicial system and the process, and that time frame sometimes takes a minute, you know. Seller disclosures, RPOs in the MOG. Everybody hear me when I say the seller's disclosures? Who's responsible for completing these forms? The seller. Can I complete it for them? No, they're not a broker disclosure. It's a seller disclosure. I can assist. I can provide the blank form. I can help them out. I can explain how they do it and what their options are. I can't do it for them. I had a seller once. She was like 80-something years old, sweetest little thing. She didn't have email. So we were doing listing paperwork. I was bellied up to her kitchen table. We were doing listing paperwork right then and there. And I handed her the RPOs, and you guys saw it in Unit 8. It's like font 6, right? Teeny tiny. They put as much on as they possibly can. She looked at me and she said, Julie, I can't see that. I said, fair enough. So what did I do? Did I grab the pen and do it for her? Nah, I put my reading glasses on and started helping her out, helping her complete the form. Can I answer that later, please? Yep, I'll get to that in a bit. So the RPOs and the MOG, seller disclosures, we can help. Most sellers have to complete the RPOs. The exception of who doesn't have to complete the RPOs would be new construction. The RPOs is not required for never before lived in dwellings. The MOG is still required for new construction, but the RPOs would be exempt. The for sale by owner is not exempt from the RPOs. So just because they're going without a broker, without representation, does not mean that they're exempt from the RPOs. Questions on our RPOs or MOG? if I'm not sure about what. The MOG is generally only not required for land, vacant land. So once you have any kind of structure on it, the MOG is required. There are a few exceptions to both these forms, but those are the big ones. Those are the big ones. And if we don't know, because let's see, the MOG asks the seller if the previous owner had severed the subsurface rights. And there is an opportunity for the seller to say no representation if they don't know if the previous seller is severed. The other two questions are, have you severed or do you intend to sever? In which case the seller's only options are yes or no. So we just have to ask them, have you severed your subsurface rights or do you intend to? The MOG also says if they have been severed, then we need to get an attorney involved, because severing of subsurface rights is a very, very legal thing, legal process. Yes, ma'am, Annette.
I'm sorry. I guess my question pretty much was, if you purchase your home but you don't know if your rights were severed, how do you check to see? Is that, and where would you find that?
I would go to an attorney, because that's going to be a recorded document or recorded interest.
So it wouldn't be on the deed or anything like that. I would have to.
It would be a separate, because there would be a deed or a lease for those subsurface rights, just for the subsurface rights, not for the whole property. So it'd be something separate. So yeah, call your attorney.
Okay, so if your owner or your buyer customer, I'm sorry, if the seller doesn't know, then you need to contact the attorney before you sit there and say, you know, that you didn't, I guess, to protect yourself from misrepresenting. If they say no, and it has been, do you supposed to check to make sure that they still have those rights before, you know, you continue?
So yeah, I mean, it's a seller disclosure. So unless we have a red flag go up, I have no reason to suspect right now. If I have a red flag go up, then yeah, now I have a duty to check. I have a duty to verify. But if the seller says no, and again, they always have the option to say no representation. So if they're not sure, if you're not sure, then the best bet would probably be to have them check no representation that the previous owner had severed those rights.
Oh, okay.
In Unit 21, we talked about the importance of us helping our clients verify their closing disclosure. CD is closing disclosure. We are going to review those things for buyer or seller for accuracy. Remember, I cannot be responsible for the whole form. That's not fair. However, I am responsible to verify those numbers that I should reasonably know. And we talked about those things that I should reasonably know. Sales price, due diligence, earnest money, seller pay closing costs. Is there going to be a home warranty? Those are numbers that I should reasonably know. How do I know that? How am I verifying that that number's right? Yeah, I see your mouths move. Isn't all that on the sales contract? Isn't all that on our offer to purchase and contract? Are there any amendments to the contract? So we can verify the figures that we can. If we've received any invoices, for example, from the home inspector, we can verify that that number's right. You guys are learning how to prorate taxes. You're learning how to calculate interim interest. Can we verify that those numbers are right? Bottom line, can we just pick up our calculator and add and make sure that the final number adds up right? So we are responsible for verifying things that we can. The examples we gave of things that we can't verify, for example, I was not privy to the conversation between the lender and the buyer. So I don't know what the lender told the buyer they were going to charge them. but I should be able to look at that and see if my red flag goes up. You know, generally speaking, it's 1, 2, 3, 4% of the loan amount. So if you see a charge from the lender for 15% of the loan amount, your little red flag should go up, cause you to ask some questions. When you find a mistake, on these things, it is our duty to contact the lender and or attorney to get it corrected. Guys, buyers, sellers don't know what these numbers mean. They don't know what this closing disclosure is or does. That's why they hired us, to help them review these for accuracy and make sure the money they're going to get or the money they have to bring is accurate, is correct. Questions? Let's take a break. We come back, that long awaited trust account. We've been dancing all around it. So we come back, we're going to talk about that trust account. Okay. Welcome back. You don't hear it? Weird. This one, I think I have Zoom figured out. It reminds me that I don't. All right, welcome back. The cameras are on. I'm going to take attendance. Welcome back. Any questions about anything we covered so far in class this morning? Moving along in our comments, we are finally at the trust account, also known as the escrow account. We've been dancing all around this, haven't we? So now we're finally here. So let's talk about what the heck the trust account is. The basic definition of the trust account, 101, is an account that holds money belonging to others. Somebody else's money is in the trust account. Your money does not belong in the trust account. The real estate firms, the real estate brokerage offices, firms, excuse me, that have a trust account also have an operating account. Not all real estate firms have a trust account, nor are real estate firms required to have a trust account. The only time a firm would need a trust account is if they're going to hold somebody else's money. Property managers are required to have a trust account. And I have taken attendance, so thank you guys. Make sure you tell me you're back. Property managers are required to have a trust account. Sales offices may or may not have a trust account. Again, if they're going to hold somebody else's money, then they must have a trust account. If the sales real estate firm doesn't have a trust account, then our our closing attorneys do. So if the firm's not going to hold somebody else's money, then the closing attorney has a trust account and they can act as the escrow agent. Why don't you guys set your private chats? And why don't you guys tell me in a trust account or in a private chat? I can't talk today. In a private chat, when I talk about having a trust account to hold somebody else's money, what are those monies we're talking about? What are some examples for property manager and sales? What are some examples of monies that we would hold or would be held in a trust account? And think about where these monies go, who they're supposed to go to. So for example, if you are property management, what are some monies you're going to hold? What are other people's monies you're going to hold? Don't we have to hold that security deposit? We got to have it in a safe place that can't be accessed, can't be authorized by other users. Think of the escrow agent as like this impartial third party. So security deposits would go in a trust account. Property managers have to have one. Rent can run through the trust account because the property manager is handling rent on behalf of somebody else. So generally speaking, the property manager will deposit rent into the trust account and then disperse it to the appropriate people from the trust account. They got to pay themselves, they got to pay the owners, right? So any appropriate fees. So for property management, yeah, pet deposits, any kind of deposit. Pet deposits non-refundable. So that may be something that we just run through the trust account just to turn right over to the owner. But yeah, for property management, generally what we're talking about is security deposits and rent. For the sales, I saw a lot of earnest money deposits, and I'm good with that. Remember, the buyers putting up earnest money is part of their contract agreement, and that earnest money just shows the buyer's good faith. And the earnest money needs to be in a trust account. It needs to be in an escrow account, just to have an impartial third party hang on to it. The other thing I saw a lot of in the chat is due diligence. Let's think about what happens to the due diligence fee. When we go under contract, who does the buyer give that due diligence fee to? They pay it to whom? The seller. So due diligence is not held in a trust account. Due diligence is paid directly from the buyer to the seller, and we can assist in making that transaction happen. So when we talk about in real estate, when we talk about who needs a trust account, it's the property manager, because they're going to have security deposits and rent. And if the real estate firm is going to hold earnest money, then they would need a trust account as well. If the firm doesn't want to deal with it, then we can let the closing attorney, because they have to have a trust account for the same reason. All the monies that come in for closings, that's not the attorney's money. That's somebody else's money, right? So the attorney runs all that money through the trust account, and then after closing, they disperse it to the seller, the lender, the agent, the various people that need to get paid. Is the due diligence paid at settlement? No, it's paid at this. The contract says it's due the effective date of the contract. Due diligence is paid the moment we go under contract. Guys, if you're going into sales, I'm going to be really honest with you. A lot of real estate sales firms, as I've mentioned, are doing away with the trust account because it is a lot of liability. It used to be once upon a time ago, trust account violations are what we saw most of in the disciplinary actions in the e-bulletin. And so once real estate firms started figuring out that the closing attorney had to do it, then we were like, whoa, we're not going to touch this anymore. So whether or not you join a firm that has a trust account, you know, some of the bigger brands still might, but I think most of us are doing away and just letting the attorney. If you do join a firm that has a trust account, they will go over their expectations, what they want from you as an agent, and how they want to handle that. So let's talk more about, I'm getting some questions, so hang on, I got more to say about the trust account. I'll probably address them. So let's see what else we know about, what else we got about the trust account. The trust account has three primary features. It's separate, and that is not the operating account. So again, if a firm has a trust account, they also have an operating account. It's separate from your operating account. It's custodial, which means people that have money in it don't have access to it. And those that do have access to it are very limited. So you as the sales associate at a real estate firm probably do not have access to that trust account. The broker in charge is going to have access to it. Maybe an employee, an unlicensed employee can maintain a trust account. So it's custodial. If you have money in it, or the custodial says that you can't have money in it. It's somebody else's money that belongs in that account. And another feature of the trust account is all that money has to be available on demand. If the funds need to be withdrawn, we don't need prior notice. Let's say your real estate firm has a really, really bad day, and every single one of your buyers terminate their contracts today. That's a bad day, y'all. What this means is that every single one of those buyers terminate today. We need to be able to have that money to distribute to either the buyer or the seller, depending on that situation. You can't look at the buyer and say, okay, I get paid at the end of the week. I'll give you your earnest money then. We're just holding it. We're being a safeguard for it. Some basic features. Like we said, it's a demand account. Commission rule says it must be in an FDIC bank. Credit unions, for example, are not FDIC. So when you go out on your own, if you want to set up a trust account, you need to make sure it's FDIC. That bank doesn't need to be located in North Carolina, but it needs to be lawfully doing business in North Carolina. And the escrow agent needs to agree to make their records available to the real estate commission at any time. So if they walk in the front door today and say, show me your trust account books, we can't say, okay, hang on just a second, let me get this together. They need to be available for inspection by the commission at any time. There's a fairly new commission rule. If you're going to be an escrow agent, if you're going to maintain a trust account, the commission has a trust account class. You're required to take that before you set up your trust account. You can find that on the commission's website under the education tab. Once you have that trust account and you've taken that class, you're required to retake the class every 3 years. That class shows you how to properly balance the books, things to look for, how to handle your entries, money going in, money going out. So it walks you through how they want their records, how they want to see those records handled. A couple other things about the trust account. The actual words, trust account or escrow account, must be on all the documents. So signature cards, checks, deposit tickets, bank statements. It needs to specifically say this is a trust account or an escrow account. Think of a one-man operation, a sole proprietor that's a broker in charge. Remember, a sole proprietor, if you want a trust account, you got to have a broker in charge. Designate yourself or get one. Let's say that sole proprietor passes away. We don't want that account to get wrapped up in their estate because it's not their money, right? So if it's labeled trust account or escrow account, then the estate knows that that's not their money and it can get handled appropriately. Escrow agents need to keep accurate records. Have records of the property address, the buyer and seller, or landlord and tenant, date it came in. You need to be specific about what that money is. Is it a security deposit, earnest money deposit? So they need to keep accurate records. Generally speaking, real estate firms and closing attorneys, generally speaking, escrow agents only have to have one trust account. So for example, let's say you're a real estate firm that does for sale and for lease. You can have the earnest money and the security deposit in one account. You could choose to set up two, but the commission rule says there's only one trust account required. If you're a property manager that's managing several properties, you only have to have one trust account. All good rules have an exception. So the exception to this rule is if you're a property manager that manages more than one HOA. All HOAs need their own separate trust account. So if you're a property manager with 2 HOAs, then you need 2 trust accounts. So it's the only exception. Otherwise, again, you can set up as many as you want to. The commission rule says you only need one unless you're managing. All HOAs need to be separate. I mentioned a few minutes ago, we used to see the trust account and disciplinary action all the time. I mean, trust account was all the time. No wonder firms are doing away with it. Now we're seeing things like agency violations and material facts. So the biggest thing that we saw when we saw trust account and the disciplinary actions all the time was something called commingling. Commingling is not allowed. Commingling is putting your money in the trust account or taking money from the trust account and putting it in your operating account. Remember, the basic definition, the trust account is an account that has somebody else's money. So we can't commingle those funds. There was a case once. It's so innocent sometimes. I don't think people are malicious. I do not. I think people sometimes just don't think things through. And there was a case one time. Somebody was behind on their bills. Times were tough. And they were behind on their bills. And they got a letter from the power company that said, if you don't pay this power bill by 5 o'clock today, we're going to cut your power. And that person said, my gosh, that's not fair. I get paid tomorrow. So how about I borrow money from the trust account to pay my power bill. And then tomorrow I'll pay it back. It'll be okay because I'll pay it back. Guys, we cannot do that. That's commingling. That, hands down, commingling is the #1 violation. And it's also a good rule that has an exception. The exception to the commingling rule: if your bank charges monthly fees, you can have no more than $100 of your own money in there at a time to cover those automatic drafts, to cover those automatic fees. So if your bank charges, I don't know, $10 a month, and they're just going to automatically draft it, you can have no more than $100 at a time of your money in the trust account just to cover the fee. When that amount dwindles down, you can replenish it with no more than $100 at a time. Trust accounts can be interest-bearing accounts, which means they can collect interest. The interest would belong to the escrow agent. Once the interest is collected, the escrow agent needs to transfer it from the trust account to the operating account. Interest-bearing trust accounts are allowed as long as the parties agree to it in the contract. Our standard offer to purchase and contract does say that the escrow agent may be an interest-bearing account. Property managers may have similar verbiage. So as long as you have that verbiage in your contract between buyer and seller or landlord and tenant, then you can have an interest-bearing trust account. If the real estate sales firm, or even the property management, if the real estate side has the trust account, the BIC is the one that's ultimately responsible for it. Even if they have an employee manage it, if the real estate commission walks in the door and says, show me your books, or we have a problem we need to investigate, they are talking directly to the broker in charge. They are not talking to the employee. They're not talking to the people that balance it every month, that kind of thing. So the BIC is ultimately responsible. Back in my unlicensed admin days, I managed the trust account for my office. But I tell you what, I had to report to my BIC every month. And if that thing didn't balance, I need not take it to him. He was pretty strict about it, as he should have been. Records need to be accurate and current. Now, they don't get specific about what accurate and current means, but I think a general rule of thumb, that bank statement comes out once a month, doesn't it? So isn't that a good time to sit down and make sure that things balance? Again, that's what that trust account class covers. It's how to properly balance, how to properly maintain it, manage it. So records need to be accurate and current. Question I got earlier was, how long does the earnest money stay in the trust account? So the answer to that is, it depends. There's a couple different scenarios, right? There's a few different things that can happen to this earnest money deposit, specific just to earnest money, this next discussion. So let's say we're getting ready for closing, right? We got this thing through closing. Commission rule says that it needs to stay in the trust account. It cannot be dispersed no more than 10 days prior to settlement. So if you're getting ready for closing, at some point, you need to request that earnest money deposit from your firm so you can take it to the attorney's office so they have all that money in their possession to process closing, process settlement. Again, your firm will have policies on how they want you to request that money. I had a clipboard outside my office. So if you wanted your earnest money, you just had to put down on a clipboard. But each firm has its own policy. So again, if you do join a sales firm that has a trust account, they'll tell you how they want you to handle that. What we know for our test is that commission rule says it cannot be dispersed no more than 10 days prior to settlement. The other scenario, what if it doesn't close? What if we don't make it to settlement? So remember, this is earnest money deposit we're talking about. If the buyer terminates within their due diligence, the buyer will get their earnest money deposit back. If the buyer terminates after due diligence, then the seller gets the earnest money deposit back. Here's the deal. The escrow agent, even though the contract is very clear about what happens to the earnest money deposit if we don't make it to settlement, if we have to terminate this contract, the contract spells out for us. It's very clear what happens to that money. Does it go to the buyer or does it go to the seller? Even though the contract is very specific, keep in mind the escrow agent is an impartial third party. They don't have the right or the power to disperse the earnest money deposit. If we terminate, they have to have a release from both buyer and seller. And we have forms for that. So if it's going to the seller, we have the party sign that. If it's going to the buyer, we have the party sign that. Again, the escrow agent is supposed to be an impartial third party. They have no interest in this money whatsoever. They're just hanging on to it on behalf of the parties. So if we terminate, the parties have to agree to release that money. And if they don't agree, if they don't sign that form, then the earnest money is disputed. And the escrow agent cannot release it on their own while it's in dispute. The escrow agent can only release it with authorization from both buyer and seller. So if either party's digging their heels in saying, no, I'm not going to sign that, the escrow agent waits a period of time. They're going to make several attempts to notify the parties, hey, I got your money. You know, we want to disperse it. And guys, bottom line, if the money's still in dispute, if we still can't get disbursement from both buyer and seller, after a certain amount of time, the escrow agent is allowed to turn it over to the clerk of courts and let the two go downtown and hash it out. They can't make that decision. They can't make that authorization, but they can turn it over to the courts. So disputed would mean that the parties haven't signed to agree to release it. Again, despite what the contract says, because remember, the escrow agent is not a party to the contract. Buyer and seller are parties to the contract. Do you have any questions on that? So question comes in about disbursement. So remember the escrow agent, the real estate firm, this is if the firm is holding the earnest money deposit. And at some point, we got to get the earnest money deposit from the firm to the attorney, because the attorney needs all that money for closing. They need the purchase price. They need the earnest money. They need to credit and debit the due diligence. They got to account for all that money. So if the firm has the earnest money, commission rule says it can't be dispersed no more than 10 days. And by dispersing it, we're getting it to the attorney so they have everything together so they can proceed with settlement. They've got to have all the monies in order to close. Remember, attorney's never going to touch due diligence. The buyer pays that directly to the seller. That's just going to show up as an entry on the closing disclosure. So your firm, if you join a firm that has a trust account, your firm will tell you how they want you to request, and they're going to hand you a check made out to the attorney for you to take it prior to settlement or at settlement, prior to closing. Other questions? Obviously, if the closing attorney's holding earnest money, it's already there, right? So they already have it. Due diligence is paid from the buyer to the seller. So at settlement, under contract, is paid from the buyer to the seller. At settlement, we're not going to exchange money. We've already done that. So at settlement, the due diligence is going to show up as a credit to the buyer and a debit to the seller. Again, we're not actually going to exchange monies. We're just going to make an entry. And that entry for due diligence is going to be a credit to the buyer, debit to the seller at settlement. Other commission rules about the trust account. Trust account monies need to be deposited within 3 banking days of receipt or contract formation. Obviously, the sooner you get it in the bank, the better. If your firm is holding earnest money, I mean, I don't know, back in my day, I had to go to the bank every single day. I'm not really complaining. The bank was like 5 minutes away and I got like 20 extra minutes for lunch. So I could work that out. But, we're into the bank every day making our deposits. So the rule says we can't hang on to it. We have 3 banking days from receipt or contract formation. So I got 2 different scenarios here. So let's talk about first 3 banking days of receipt. Let's say we go under contract today. The contract says that the earnest money is due within 5 days of the effective date. So just because we go under contract today, does that mean we're going to have the earnest money in our hand today? No, we got 5 days to get it. So we go under contract today, you get that money tomorrow, you have 3 banking days from tomorrow to get it in the bank. 3 banking days from receipt. The second piece of this is 3 banking days from contract formation. Let's say, for example, you're working with a buyer. Maybe it's an out-of-town buyer. They come into town for the week. You spend the whole week with them, showing them 20 properties. At the end of the week, they decide which one they want to buy. They hop on a plane and go back home. Before they hop on the plane, they hand you their earnest money deposit. We feel good about it. We think it's a good amount. The buyer hands you their earnest money. I'm not under contract yet. We haven't even filled in the blanks of the offer. We've not presented the offer yet. The buyer doesn't owe any money until a contract is formed. So they hand you that earnest money, you present the offer, we negotiate the offer, and then we go under contract. Your broker in charge is going to hang on to that earnest money deposit until and if the contract is formed. Once we have contract formation, we already have the earnest money deposit. Once we have contract formation, now we have 3 banking days to get it in the bank. So the rule says must be deposited within 3 banking days of receipt or contract formation. The exception, guys, is cash. If your firm has a policy to accept cash, to allow cash for an earnest money deposit, get it in the bank immediately. Because if that contract's never formed, we can always reimburse for cash, right? I got to wait for a personal check to clear the bank, which is why we're not going to deposit it. But if it's cash, they say, I'm getting back on the plane. Here's $5,000 in cash. We can get that in the bank. And if that contract's never formed, then we can write a check and get it back to them. And I have to wait for it to clear. Questions on this? You guys as provisional brokers need to know something about trust monies. Everybody ready? You as a provisional broker cannot walk around with somebody else's money. As a PB, if your buyer says, here's my earnest money deposit, hang on to this for me while we're negotiating our offer, you need to take that check immediately to your broker in charge. Provisional brokers cannot walk around with somebody else's money. A full broker can, but that doesn't mean that they should. A full broker can hang on to that earnest money deposit, but they do have the option of turning it over to their bid. PBs cannot, brokers should not. Guys, here's the deal. Bottom line, When you have somebody else's money in your possession, who do you think is responsible for it? You are. Bottom line, if you have somebody else's money in your possession, you are responsible. So the suggestion is get it to where it needs to go. PBs cannot walk around with somebody else's money. Run, don't walk. Get it to your broker in charge and let them hang on to it until and if a contract is formed. Everybody at some point, provisional broker, full broker, or broker in charge, everybody at some point may act as the courier. Maybe it's an option fee. Maybe we have the due diligence fee. Listing agents and selling agents, we're going to help deliver that due diligence fee from the buyer to the seller. We're going to assist in that transition. We have 3 days to deliver. So again, once you get it in your hand, get it to where it needs to go. All monies that you have that belong to somebody else is your responsibility. So what I'm telling you guys is don't wait 3 days. Get that due diligence fee to the listing agent or the seller, whomever. Get it to where it needs to go. Get it off your hands. The last page of our offer to purchase and contract shows receipts of due diligence. It shows receipt of earnest money. So it's not your word against theirs. People are actually going to sign, acknowledge, and receipt so we can see that that happened. When it comes to due diligence and earnest money, well, anything. When it comes to somebody else's money, guys, remember, for due diligence and option fees, for example, I'm allowed to touch it just to play courier. I don't have an interest in this money. This isn't my money, right? This is the seller's money from the buyer. So let's say, for example, you're a buyer's agent and you guys go under contract and you meet your buyer this morning in a parking lot somewhere so you can get the earnest money and the due diligence fees so you can take them to where they need to go. And you meet your buyer and you get those checks in your hand and you are en route to deliver them. And the buyer calls you and says, do not deliver them. We have got to honor their request. It's not my money. It's their money. I am simply playing courier. I am simply acting as delivery guy. So if the buyer says, don't you deliver that check, obviously you can say, well, if the seller doesn't give them, this could give them a right to terminate the contract, right? Tell them the consequences of not delivering it. But if they say, I don't care, do not deliver that money, we've got to honor their request because it's their money, not ours. Again, we can go over the consequences of what can happen, but we cannot control or regulate what happens with this money because it's not ours. I give it back to my buyer. I'm not even going to give that to my BIC because it's not my BIC's money. It's the buyer's money. So if they say don't deliver it, I'm going to say, are you sure that seller could terminate? They could maybe sue you. I don't know. I'm not an attorney, but there could be consequences to this action. And if the buyer says, I don't care, bring it back to me, or shred it or destroy it or whatever, we follow their instructions. Now, once it leaves your hand, can I do anything about it? If I deliver it to the listing agent, they call and say, don't deliver it. Well, it's too late. It's out of my hand now. So that takes me back to anytime you have somebody else's money in your hand, get it to where it needs to go. You are responsible. You are liable. And actually, that takes us to this slide. Everybody, I don't care who you are. We are all responsible for safeguarding somebody else's money. I don't care if your firm has a trust account or not. Due diligence monies, earnest monies, option fees, security deposits, rents, that's all somebody else's money. And we have a duty as licensees to safeguard them and do what our clients instruct us to do. It's their money, not ours. Questions? Anything on the trust account? The last piece in this comment section, again, is a quick little review. On Unit 17, we talked about broker price opinions and comparative market analysis. So when you read those comments, you'll have some additional information and additional source. BPs, provisional brokers, you can do a BPO, but you cannot do a BPO for a fee. Remember, we talked about doing a BPO for an impartial third party, maybe that relocation company in another state that just wants your opinion on the probable sales price of that property. You can do it, but you can't do it for a fee. They can't pay you for that service. Nobody can charge for a fee when it's just part of our general brokerage duties. So you can't go to a listing appointment, and when the seller says, what do you think I should list my house for? You can't say, well, cash at me some money and I'll let you know. Guys, that's just part of our job. Same thing with the buyer. When your buyer client says, I want to make an offer, how much should I offer? We cannot look at them and say, you got to pay me for my opinion. They already are. It comes in the form of commission. So nobody can charge a fee for part of general brokerage services. The provisional broker can't charge a fee to do it for an outside third party. Remember, we don't get to determine value. Better yet, we don't get to use the word value. That word is set aside for a licensed appraiser. The words that we use, we give our estimate probable sales price or probable lease price. BPOs and CMAs are one of those things. They're unique in the fact that they're covered under both license law and commission rule. LL is license law, CR is commission rule. And there's license law and commission rule regarding CMAs and BPOs. So if you do, once you drop your provisional status, if you are called on to perform a BPO or CMA for a fee, then it's got to be in compliance with license law and commission rule. Again, so much more training. We talk about scratching surfaces. I mean, we just briefly introduced you to CMAs in this class. Once you guys get licensed and affiliate with your firms will spend time with you, making sure you're properly performing these under license law and commission rule. And then the other thing covered is that they got to be in writing. You guys going to document it when you do a CMA or a BPO? Yeah. Questions on BPO, CMA. BPO, CMA. So this gets us through the comments section. The rest we had to talk about are just scattered throughout license law and commission rule. I did not ask you guys to read that. I asked you to focus primarily on the comments because the comments are the bulk of the state section of your exam. But there are other state specific stuff that you could be tested on, and that's what we're going over now. So we're going to go, we're not going off book. We're just going off material that I asked you guys to cover. Question comes in about CMA. We can charge a fee if there's no listing contract or if you're not trying to get a listing contract. So if you're going on a competitive listing appointment, how much are you going to sell my house for is going to come up. So we need to do a CMA to get ready for that listing appointment, but you're doing the CMA for the hopes of getting that listing. Does that make sense? Competitive listing appointment. The seller's talking to 3 agents. 2 of them say, here's my CMA. 1 of them says, give me $20 and I'll share this with you. Is that 3rd agent going to get the listing? Nah. Competitive listing appointments are very real right now. Guess what? Competitive buyer consultations are becoming, you guys got to bring your A game every single time you talk to potential buyers or sellers. Because they're talking to other people trying to decide who to hire. Does that make sense? So other things covered under license law and commission rule. Commission required us to have a proof of license. Now, once you get licensed, once you get your license, they're going to mail you an 8x10. It's going to look something like this. Isn't it pretty? Can't you wait? Here's your carrot. Here it is. So they will mail you a nice license, get you a frame. You can see I did. Hobby Lobby puts them on sale, what, every 3 weeks or so. So that gets you a frame. Y'all worked hard for this. So when you get it, frame it, display it, and be proud. In addition to this, every year that you renew your license, they're going to provide you with a pocket card. The pocket card, you can print it out and carry it around in your wallet. Or as of a couple years ago, they have a digital version you can put on your phone. If you're a nerd like me, you get both. I got it on my phone, I got it in my wallet, I'm covered. The commission requires our pocket card to be on us at all times that we're engaging in brokerage activity. So I don't have to walk around with this, but I do have to have my pocket card on me. You get a new one every year that you renew. We're going to talk about renewal. In addition to the individual agent having a license, the firm also has a license as well. The firm has to renew every year as well. The firm is required to display their license. You can choose to if you want to, but the firm is required to display their license. So we have our proof of license. Brokerage activity. Is doing an open house a brokerage activity? Is going on a listing appointment a brokerage activity? Buyer consultation, showings? What about going to CE, continuing education? Are those brokerage activities? So again, they make it easy, you guys. You can either keep it in your wallet or keep it on your phone. Which one do you have closest to you at all times? Just have it on you. I know a lot of schools require the pocket card for admittance into CE. That's your ticket into CE, is to have your pocket card. So yeah, just have it with you. Another thing covered under a commission rule, we've actually seen this one. We cannot disclose the terms of the offer without written permission of the offeror. Who is the offeror? Don't you say buyer or seller. Who is the offeror? The giver of the offer. Doesn't care if it's buyer or seller. The giver of the offer. So we cannot disclose the terms of an offer without their permission. So let's say, for example, you're a listing agent and you find yourself in a multiple offer situation. You start getting lots of offers in. There's going to be a selling agent that calls you. There's no rule that says they can't call you. There will be a selling agent that calls you and says, what's the highest priced offer you have in your hand right now? Can you answer that question? Not without the express authority of that person making the highest priced offer. Everybody with me? There's no rule that says that they can't call you. The rule says how we respond. In that case, we're going to say something like, your buyers need to bring their highest and best. We will consider all offers at this date and time. What if you're a buyer's agent and you have two buyers interested in the same property? Can you pit your buyers together? I know the Joneses are offering this. This is what the Smiths are up to. Can we pit those buyers together? No, we got to keep it fair, don't we? So we're going to do one CMA for both, and we're going to let them decide how much they want to offer. One thing I learned, all buyers have a different risk tolerance. And so if we provide accurate information, accurate CMAs, they will decide what they're comfortable offering. Does that make sense? We cannot have offerors shop their offers. We can't pit them together. So we cannot disclose the terms of an offer without the offeror's written permission. Do you think any offeror in their right mind is going to give you permission to disclose the terms of their offer? No. Yeah, tell them how much I offered. See if they want to beat it. No. Do you have to tell them you have other buyers interested? The presence of multiple offers is not a material fact. Whether or not we disclose we have other offers is up to the seller. So we have a conversation with the seller. If they want to tell other buyers that we have other offers, it's not on itself a material fact. Multiple offers. Anything else? So we don't owe old car to our buyers. Well, if you're the buyer's agent, you're not going to know if there's multiple offers. If you're the listing agent, you're going to know if there's multiple offers. What we tell our buyers is that they need to present their highest and best offer, whatever they're most comfortable offering, based on the CMAs, based on our information that we provide. Remember, I'm a fact finder. My job is to help provide them the information so they can make an informed decision. Am I buying this house? Nah. Other questions? I know I'm a few minutes early, but again, we're getting ready to go into the next topic, so I don't want to start it. So let's go ahead and take 10. We come back, we're going to talk about your license renewal, how you keep it active once you get it. So let's come back on time so we can all learn this. 10 minutes, please. guys hear the alarm this time? Did you hear the alarm? Some of you do, some of you don't. This could be interesting in a minute when I try to show you a video. Some do and some don't. Weird. Check the settings on your end to make sure. Well, if you can hear me though, but it's the sound coming from my laptop that you can't hear. This is me trying to put it together. Trying to act like I know what Zoom does. We'll see what happens in a second. All right. So I am taking attendance. Now we're going to talk about once you get your license, what do you do with it? So let's understand a few things. Our renewal period. Every single real estate license expires at midnight on June 30th. All of our licenses expire on June 30th, unless we renew them. Why June 30th? By the way, that's a super important date that you need to know. The Real Estate Commission's physical year is July 1st to June 30th. The Real Estate Commission does not operate on a calendar year. They operate on a physical year. Perfect. You should remember that. They operate on a physical year. And they have the renewal period every single year from May 15th to June 30th. The renewal period just opened up on Monday. So all licensees have from May 15th to June 30th to renew their license. How you renew your license is by submitting the renewal fee. You renew your license by submitting the renewal fee between May 15th and June 30th. This year, last year, the past, I don't know how many years, that renewal fee has been $45. It may go up one day, I don't know. But for the last, seriously, as long as I can remember, that renewal fee has been $45. When you renew your license, when you pay the fee between May 15th and June 30th, your license effective July 1st is current. So the first step in practicing real estate on July 1st is to renew your license to have a current license. Failure to renew the fee means your license is expired. So if you don't send the fee in, they don't have it by 11:59 p.m. on June 30th, the stroke of midnight on July 1st, your license is expired. Do you think you can practice on an expired license? You think you can advertise your services, receive commission, collect a referral fee? What can you do on an expired license? Pretty much to say, I used to be a real estate agent, right? So an expired license means you cannot do anything. So the first step in having a license is to renew it, is to pay the fee. The word current is it's $45 a year. The word current is so important. When you guys see that word current, I need flags to go up all over the place. A current license only means that you've renewed the fee. When you see the word current, I would like you guys to actually see the word currency and think about money. A current license has everything to do with paying the fee. It has nothing to do with education. I'm getting to the education piece of it next. So step one to renew your license every year, step one to have an active license next year. First off, you have to renew, you have to pay the fee. When you see the word current, think fee. So the first step, either you pay the fee and you have a current license, or you don't pay the fee and you have an expired license. May 15th to June 30th. They used to mail out cards reminding you of the renewal period. They just started last year, I think. Only email notices only. It's on the commission's website that it's the renewal period. Your BIC will remind you. Guys, they started telling us, because the renewal period just opened up, what is that, on Monday? They started 3 weeks ago reminding us that the renewal period is coming. Our BIC started reminding us 2 weeks ago that they were, right? So now that we're actually here, now everybody can log on to your account on the website, licensee log on the website. You put in your information and poof, you've paid the fee and your license is current. Please hear me. A current license has everything to do with paying the fee. It has nothing to do with education. So pay the fee for a current license. Don't pay the fee for an expired license. Questions so far? Okay. Once you renew the fee to have an active license, you renew the fee for a current license. How do you keep an active license? Now here comes the education. Let's understand. A current license can be one of two things. A current license can be active, meaning you're up to date on your education, or it can be inactive, meaning you're not up to date on your education. I'll talk about inactive in just 1 second. I'm going to talk about what happens if your license expires. Please bear with me. So a current license can be one of two status. It can either be active or inactive. If your license is active, it's because it's current, meaning you pay the fee and you're up to date on your education. You guys will all have to do CE each year. I will talk about CE in just 1 second. As a provisional broker, take this active status a step further. To be active as a PB, you have to be affiliated with a BIC. So not only do you have to pay the fee, do your education, you also have to be affiliated with a firm, with a broker in charge. So the active license is current and you're up to date on your education. An inactive license then is current, which means what? It's current because you have shown them the money, right? You sent in your fee. It would be inactive because you're a provisional broker without a BIC. You don't do your CE on time. You don't do your post licensing on time. Why don't you guys remind me in a private chat? Private chat. How long do you have to complete post licensing once you're licensed? How long do you have as a provisional broker to complete post licensing? How long do you have? Once you get your license, you have 18 months to complete post licensing. Failure to complete post within 18 months means that your license will be inactive until you get it done, assuming you've paid the fee. So step 1, did you pay the fee? Yes or no? Step 2, what's your education? Are you up to date on your education? You could also choose to go inactive by choice. Maybe you think you're done with real estate, you want to put it off to the side, but you don't want to let your license expire. I'll talk about that in just a second. So you think you're done with real estate. Maybe you need to take a break to start a family or care for an elderly parent or start a new job, right? Life happens, yes? Life happens. So you decide to put real estate on the back burner for a bit. You can ride for the rest of your life on an inactive license. All you have to do is send the fee in every year. Why would you send the fee in to ride on an inactive license for the rest of your life? I will talk about that in just 1 second. So it's current, meaning you have paid the fee. Once your license is current, depending on your education, is whether or not it's active or inactive. And yes, I'm going to talk more specific about CE in just 1 second. Please bear with me. Questions just on this: current, active, or inactive? So let's say you've had an inactive license for a year or 10 or 15, whatever. You've been paying that fee, sending that money in every year. You've been renewing your license, paying the fee, and riding on an inactive license. And you wake up one day and you decide you want to activate your inactive license. How you activate your inactive license: you've been paying the fee every year. But if you want to activate your inactive license, it depends on your education deficiency. So on an inactive license, if you have still been doing CE every year, you can do CE on an inactive license. And if you keep doing CE, you wake up and say, I want to get back into real estate. I want to be active again. All you have to do is submit the form. You're current because you've been paying the fee. But now you're just requesting it, and you're up to date on your education. So now you're just requesting to change your status from inactive to active. If you have not been doing CE, if you have a CE deficiency, if you haven't done CE in the last 2 years, they're going to make you do an extra elective. We're going to talk about the current year CE in just 1 second. Each year we have to do an update and an elective. So if you haven't done CE in the last 2 years, they're going to make you do this year's update and elective. And then they may also make you catch up by doing an extra elective or 2, just to help satisfy that education deficiency. So you've been inactive, which means you've been paying the fee, but you've not been doing CE. So they're going to make you do some extra CE to get caught up. If you've been inactive for more than 2 years with a CE deficiency, they're going to make you do this year's CE, and then they're going to make you come back and do 2 out of 3 post-licensing of your choice. You can do whichever 2 you want to do. So if you think you're done with real estate, I always recommend paying the fee. If nothing else, sending that fee in every year. And again, I'll talk to you about that why in just a second. But you may want to consider doing CE at least every other year. So if you do get back into it, you don't have to come back to post-licensing. Does this make sense? If you're inactive for more than 2 years, no education, you wake up one day and say, I want to be active again, they'll activate you, but they're going to make you take CE, and they're going to make you come back to post-licensing. It's up to you if you guys want to do that or not. Questions on reinstating an inactive license? It's inactive. Why? You guys can all show me. It's inactive. Why? It's a current license. Why? You show them the money. It's inactive because your CE, your education is deficient. Questions on active versus inactive? Can you practice on an inactive license? Can you tell everybody you're in real estate? Can you collect a referral fee? Can you hand out a business card on an inactive license? What can you do on an inactive license? Nada. Not a darn thing. Peter, no, I'll talk about that in just a second. Yep. So this is all active and active says we've paid the fee, right? A current license can be active or inactive. So now the question comes up, well, what if I don't pay the fee? If you don't pay the fee, you have 45 days to pay $45, basically is what we're saying, May 15th to June 30th. At the stroke of midnight on July 1st, if they haven't received your fee, your license is expired. Everybody with me? Current versus expired. It's all in the difference of paying the fee. So if your license goes expired, how do you reinstate an expired license? It depends on how long it was expired, excuse me. It depends on how long it was expired. So if it's expired for less than 6 months, you pay the $45 renewal fee, you pay a $45 reinstatement fee, and then you're good to go. So if you wake up on July 1st and go, oh my God, I did not pay that fee. Are you kidding me? It's cool. Just send in $90, $45 for the renewal fee, $45 for the reinstatement fee, and you're active again. Less than 6 months, you pay the fees. If your license is expired from 6 months to 2 years and you want to reinstate it, you want to get back into real estate, it's been expired for 6 months to 2 years. You pay those 2 fees, the renewal fee and the reinstatement fee. And then you have a choice. You can either go back within 6 months and take a post licensing class, or you go back to PSI Testing Center and pass both sections of the state exam again. What do you think most people choose to do? Post licensing, sure, but you have a choice. So you're expired for 6 months to 2 years. You pay the fees, renewal fee, reinstatement fee. You either take one post licensing class of your choosing, or you go back to PSI Testing Center and take the state exam again. I see mouths dropping already. Wait till the next slide. Y'all want to know what happens if your license is expired for more than 2 years? More than 2 years. Everybody ready? You want to reinstate a license that's been expired for more than 2 years. You have to start all over. Remember day one of pre-licensing? Yeah, that's where you are. See why I think it's worth it to pay that fee every year? Is it worth sending in the $45 every year? Maybe you're done with real estate, maybe you're not. I don't know. I can't answer that for you. Guys, this happens all the time. The last in-person class I taught, I had two people were there because their license had been expired for more than 2 years. And I do think genuinely what happens is, again, life happens. Life happens. And we think we're done with real estate. And then something else happens. And guess what? I think I want to get back into this. And you call the commission and you say, I've been expired for 3 years, but I'm ready to do it again. What do I do? And the commission says, find a good pre-licensing class because you've got to start all over. What are you guys going to do if you expire? I can't answer that for you. I personally think it's worth the $45 every year, even though I think I'm done. That's just me, though. You guys have that decision to make. Question comes in, what about new PBs that are inactive? You're still current. You're just inactive until you affiliate with a firm. So again, your license is either current or expired. It's current. Why? Because you have shown them the money. A current license has everything to do with the fee, paying the fee. It has nothing to do with education. So once you pay the fee, then the next question is your license active or inactive? And that depends on if you're a provisional broker, if you're up to date on your education, all that good stuff. What if it's active when you complete the transaction? So let's say, and this is more of a post licensing, but just real quick, if the commission allows a brokerage firm to pay a licensee, if their license goes inactive, the firm may be able to pay the license fee as long as the brokerage, the majority of the deal, right? So if closing is going to happen on July 2nd, your license expires on July 1st, the commission would allow the firm to pay you, but that's up to the firm's policy. The second piece of that is you've got to stop all brokerage activities once that license goes active or expired, excuse me, or inactive. So in other words, you wouldn't be able to go to closing. So the commission will allow it. And again, you'll get more into that in post. The commission will allow it. It's just up to the firm. to the firm's policy. Questions about current, expired, active, inactive? What if you receive your license a week before the renewal date? I put a letter for you guys in the online learning system under the welcome tab from the commission that addresses if you get your license before July 1st. We put that in a couple weeks ago as soon as we got it in our hands. So if you fall into that category, if you're going to get your license between now and July 1st, I need you to go to the welcome section of the online learning system and look at that letter from the commission explaining how that works for you. You guys are at a very interesting point because we're in the throes of the renewal period. So it just depends on when you go to PSI testing center and when you get your license. Again, if you're going to get your license before July 1st, please go into the online learning system in the welcome section and look at that letter. Anything else? Current, expired, active, inactive? I think we're all goods on this. How does a provisional broker activate their brand new license? PBs can only be active if they're under the direct supervision of a broker in charge. That's it. One step at a time. Once a provisional broker is under the supervision of a broker in charge, you can do just about everything a full broker can do. You can list properties for sale. You can work with buyers. You can assist in contract negotiations. You can measure. You can do CMAs. Once you're under the supervision of that BIC, you can do just about everything that a full broker can do. The few exceptions that we've talked about, a provisional broker cannot charge a fee to do a BPO. A provisional broker cannot walk around with somebody else's money. A provisional broker cannot be designated opposite of their broker in charge. That's it. Other than that, you guys go nuts because you are under the direct supervision of a broker in charge. When you submit your application, make sure you have the funds to pay the fees, the application fee, the testing fee. That comes back declined. They may consider that when they're considering your license. When you renew your fee each year, your renewal fee each year, make sure you have the funds. Commission rule says they could discipline your license or just not issue it. Let's talk about CE. There's a whole separate commission rule section just on CE. So again, we're just pulling out the testable points, of course, and the stuff you guys need to know upon initial licensure. So when it comes to CE, let's talk first about what we're dealing with. All licensees that want an active license have to complete 8 hours of CE each year. And the deadline to do CE each year is June 10th. So a couple of dates that we just need to know. Your renewal period is May 15th to June 30th. The renewal period is when you have to pay the fee. CE is due by June 10th every single year. Failure to do CE by June 10th means at the stroke of midnight on July 1st, assuming you've paid the fee, your license will go inactive. So pay the fee, always just pay the fee. But assuming you pay the fee, but you forget to do CE, on July 1st, your license will go inactive until you get caught up on your CE. the commission has a blackout period from June 11th to June 30th. No education provider in the state can offer CE for CE credit. We can offer the class, but I can't give you credit for it because the commission has put a blackout period on it. Guys, they're processing all these renewal fees. All these firms have to renew during this time. Real estate schools have to renew during this time. Instructors have to renew. Everybody's renewing from May 15th to June 30th. At last count, there are like 109,000 licensees in this state. That doesn't include firms, schools, instructors. So the commission's processing a lot right now as of Monday. Yes, they're processing a whole lot. And at some point, they got to cut that CE off to allow everybody to get their credit. So June 10th is the deadline for CE every single year. I think this date is right up there in importance with like your birthday and anniversary. This is a super important date because failure to complete CE by June 10th means, assuming you paid the fee on July 1st, your license is inactive. Once upon a time ago, I used to kind of be the admin or the lane of a real estate school. And I'm telling you guys right now, my phone was blowing up on June 11th. That was the day I hated going to work. I didn't take CE. What do I do? Well, get your affairs together because you know what's going to happen on July 1st. Out of our control, nothing we can do about it. I don't recommend waiting until June 10th to do CE because in-person classrooms can fill up. And once they meet the max, they don't have room for you. My suggestion is to take CE when you can. Usually schools start offering about August or September. So you have the better part of 10 months to take CE. A lot of agents, some agents like to do it in the middle of winter. Historically, that tends to be a slower season for us, December, January, something like that. So that may be a good time to take CE. You can do it on June 9th or June 10th, but just remember, if you're going to do your CE on June 10th, guys, they can't grant a hardship. So if you're going to do your CE on June 10th and you're going to do it on Zoom and you wake up that morning and Spectrum has your internet out, are you going to be able to make up that CE on June 11th? No. What if you're going to go in person and you wake up that morning and you have a flat tire? What can you do about it? Game over, right? I'm begging you guys not to wait until June 10th. I call you my daredevils. Please don't be a daredevil when it comes to these dates. So the deadline for CE every year is June 10th. The two classes we have to take, they break those 8-hour classes down into a 4-hour update course and a 4-hour elective. The update is the same for all licensees across the state. It's the material that the commission feels that we as licensees, all 109,000 of us, need a refresher on. I need to know. It's their opportunity to communicate with us with the update material. If you're a broker or a provisional broker, you will take the general update course. If you're BIC eligible or the designated broker in charge, you'll take the BIC update course. Still the same material, just a little bit more victim for our BICs. So the update course, the commission provides the topics. What did they get the most complaints on last year is usually an update course topic. In addition to the update, we also have to take 4 hours elective, and the elective is a topic of your choosing. You can, if you have a niche, if there's something you want to learn more about, you can focus on that elective course. You can choose what topic, as long as it's offering elective credit, which it'll tell you. As long as it's offering elective credit, then you can get your CE credit that way. When you complete CE, I just got a question. When you complete your CE, you will get a certificate. You don't need to send your certificate to the commission. The director of the school will report that CE credit for you. So just hang on to the certificate. I hate to say this, but there's a lot of people that have to touch it. So just in case something gets mixed up, you have that certificate to prove that you were there. So the director of the school will submit your CE. You can go in, once you finish CE and post, you can go into your record and see that it's posted. So you can see that you got the credit. So again, you'll have that licensee log on and you can go in and access your record. Questions on CE. No tests in CE. Isn't that fun? Once you get through post, there's no more tests. The only time you may be tested in CE is if you do a self-paced elective. And then they're like every hour going to throw you some questions to make sure you're sitting there paying attention. Right? So that's the only time you would have your Zoom or in person CE. There is no, yes, Lakeisha, because we're getting over exam rules and expectations. So where are you? Thumbs up me. Perfect. Perfect. Thank you. Any other questions on CE? So the question I get, do you have to do CE your first year as a licensee? And the answer is no. Once you get your license, you can take that first year CE off. You don't have to do CE until your second renewal period. So the day you get your license, I need you guys to take a piece of paper and a pencil, and I need you to draw out a timeline. That timeline starts with the day you get your license. The first time you hit June 10th, you don't have to do CE. If you get your license on July 1st, you don't have to do CE that renewal period. If you get your license on June 9th, you only get that one day. Does that make sense? So I need you guys to draw the timeline. The day you get your license, the first time you hit June 10th, you don't have to do CE. Listen to me. Always pay the fee. Yes, you just got your license, but you still have to renew that first year. So always pay the fee. Again, if you're getting licensed before July 1st, look at that letter because it breaks all that down specifically. The thinking here, you guys, is that you just finished pre, you may be in or have just finished post. So you're getting the current information. So you guys get your first year off of CE. Is that good news? Next year and on, if you want that active license, you need to take CE. You can take CE your first year, but you don't have to. So as a reminder, I cannot stress the importance of these dates. June 10th is the deadline for CE. They will not grant an extension for a hardship. They may, I should rephrase that. They may grant an extension for a hardship. But let me explain, you guys. A hardship is not, I got busy and I forgot. A hardship is active military deployment, serious medical issues. Interestingly enough, in 2020, they counted COVID, the pandemic, as a hardship. So they gave extensions for CE, but we still had to pay the fee. Do CE by June 10th, pay the fee by June 30th. Questions on the dates? I'm going to talk about post next in just 1 second. Commission rule also has a whole section on post licensing. We know now we have to do a 330-hour for a total of 90 hours post licensing. All 90 of those hours have to be successfully completed, which means you have to pass all 3 tests within 18 months. Common question I get, does post licensing count for CE? And the answer is no, because they are 2 different things. Post licensing is designed for brand new licensees. CE is for all licensees. So the 2 are not the same. You can't use post for CE credit. You can't use CE for post credit. They are 2 different things. I don't think it shows you the fees you owe. I think it shows you what you've done, not what you need to do. Again, that 18 months, it's going to be rare for them to grant a hardship. Guys, you're not going to be able to call them and say, I was so busy working with buyers and sellers that I forgot about post-licensing. Can't you give me 2 more months? You know what they're going to say? They're going to be polite and say no before they hang up on you, okay? They're not going to grant an extension because you got busy. If you have a hardship, then you need to discuss it with them. Like I said, like active military deployment. Questions on post? By the way, when you get your license, there's a date on your license. That's what starts your 18-month clock. So when you get your license in the mail, look at that date, and that's your 18-month clock. Every single one of you are going to have a different 18 months, presumably, because you're all going to get your license on a different date. It's up to you to keep up with that 18 months. The commission is not going to call you and say, it's been 15 months, don't forget to do CE. That's up to you. They will remind you that the CE deadline's coming up. My gosh, they're already annoying about the renewal period. They will remind you about those dates. They're not going to remind you about post licensing. That's on you to keep up with. The last thing we have to say, hang on, is a quick refresher on timeshares. We've come full circle, haven't we? One of the earlier things we talked about, now we're going to end here. So again, this is one of those rare things that falls under license law and commission rule. Just to give you, here's a reference. What do you remember about timeshares? You guys want to show me? What do you remember about timeshares? Y'all want to do it together? Yeah, there it is. 5, 5, 5, 10. Jazz hands. No jazz hands on test, but just try to have fun. So what does that 5, 5, 5, 10 mean? When it comes to timeshares, the definition of a timeshare is the right to occupy at least 5 or more separate time periods over at least 5 years. Understand 5 is the minimum. If you have 10 separate time periods over 10 years, you still have a timeshare. 5 is the minimum. So it's the right to occupy a unit at least 5 or more separate time periods over at least 5 years. The buyer has a 5-day recession period. So we go under contract, then the buyer has 5 days to decide if they want to proceed with the contract. And if they exercise this 5-day recession period, they can terminate their contract and get their deposits back. That's what it means to rescind your contract. The 10 is how long the developer needs to keep those deposits in the trust account. They need to have it available in the event that the buyer terminates within the 5 days. The developer has the right to make sure that the funds have cleared before they issue the refund check. But they got to keep it in their escrow account for 10 days. After 10 days, then they can move that money from their escrow account to their operating account and do whatever they want to with it. And then the timeshare developer is the only time that the real estate commission can fine a licensee. And they have the right to fine that timeshare developer up to $500 per violation. I want to show you guys something real quick. I'm going to stop sharing just for 1 second. Bear with me, don't go anywhere. We have put the comments for you guys in the online learning system. And the reason I keep sending you guys to the online learning system is because that's where the most current comments are. You have the entire license law and commission rule as Appendix A in your textbook, but please listen, what's in your book is out of date. So the reason we've been driving you to the online learning system is because that's where the most current is. With that being said, at the end of Appendix A, there is a good key point review, a good summary of what we just talked about. And then there's also a student quiz. So this is at the end of Appendix A. When it comes to reading the comments, though, I recommend looking at the online learning system because that's where the current material is. You also have some license law and commission rule quizzes in the online learning system under that category. Make sure you're doing those quizzes. Again, you guys, here's the deal. National section versus state section. The national section tends to be more in general because it covers the entire country, right? Like it's the broad overview of everything. The state section tends to be more general, tends to be more specific because now we're just focusing on the state of North Carolina. So the majority of your state specific is coming from the comments and the material we just covered. Questions? Guess what, you guys? There's all your testable material. Y'all know what I know. We did it. There you go. Don't go anywhere yet. I'm not done. Don't log out yet. We're going to talk about what we're going to do the rest of the afternoon or the rest of our time together. Everybody have these? Everybody good? All right. Before break, we need to talk about safety. Now, safety is probably just as important as anything else we've talked about. It's not testable, but I don't want you to negate the importance of this material. So what I have here is a safety video. National Association of Realtors put this out, I don't know, several years ago. Well, it says 2018. So I want us to watch the video first, and then we're going to have a discussion on safety, and then we'll talk about what the rest of the morning. So when I hit play, if you guys would give me the thumbs up, let me know you can hear it, because that would be good.
As a real estate professional, you are in a unique position that most working professionals never face. In your business, you often share your contact information openly with others, meet unknown clients, and walk through vacant properties, to name a few. It's because of the unique nature of this business that it's critical for all real estate professionals to have personal safety protocols in place that you follow every day, with every client, every time. So what kind of safety protocols should you implement into your daily routine? Here are a few to consider. When meeting a client for the first time, do not meet a new client at a property right away without first having an initial meeting at your office or a public space, like a coffee shop. During the initial meeting, make copies or take photos of the client's driver's license and pre-approval letter for your records. This precaution allows you to keep a record at the office of who your clients are, their information, and a calendar of appointments. When first meeting with a new client, you should discuss the types of real estate they're interested in and walk them through the safety protocols you have in place for all clients. Now you can arrange showings, meet them at properties, and schedule open houses to help them through the biggest financial decision of their life. When viewing a property, it's okay to ask your client to drive separately. This is a safety precaution for you as much as it is for them. Not to mention you might both have appointments to go to before or afterward.
Hey, this is cute.
As you tour a property, walk behind your client. This routine safety measure allows them to see the room first and make their own impressions. Many agents do not go into attics, garages, or basements as an additional safety measure. But encourage your client to look around and let you know what they think. It is a safe practice to only show vacant properties which might not have electricity during daylight hours. This allows you to see what safety hazards may exist, like a loose floorboard or any defects the house may have.
It's got potential.
When holding an open house, Advise your clients to board their pets and remove jewelry, family photos, credit card receipts, artwork, prescription drugs, and any other valued possessions from the home in advance of the open house. This is just one way to look out for your client and to keep their property and belongings secure. Keep a record of who entered the house by asking everyone who walks in the door to sign in with their name and phone number or show a photo ID. There is something to be said about safety in numbers. Consider bringing along a colleague when holding an open house. If there are several potential buyers walking through the home, even better to have 2 agents on hand to answer questions and keep an eye on things. Safety is an important part of real estate. Be prepared and follow the protocols and processes that have been put in place to keep you and your clients safe. For more information and additional resources, visit www.nar.realtor/safety.
Have you guys thought about safety yet, working with buyers and sellers? Have you considered this piece of it? I don't want to scare anybody, but the truth is you guys are going into a business, you're opening yourselves up to the public. Can we trust everybody in the public? Unfortunately, no. So your safety, you always need to have your safety front and foremost. I think this video gives us a few good ideas of things to consider. I want to open the floor for discussion in just 1 second, but just a couple things to hit on first. You all need to set up your own safety protocols. And remember, what does fair housing say? What you do for one, you do for all. So if you demand somebody meet you at a public place before you show them a property, you got to do that for everybody. If you want somebody to send you a copy of their driver's license before you meet them, you got to do that for everybody. Everybody with me? So set up your own safety protocols and follow them every single time. Your firm probably has some policies or recommendations as well. Again, just trying to keep everybody safe. Probably the number one question I get, can I conceal carry when I'm showing property? And the answer is, if you have your concealed carry permit, then sure. Your firm may have a policy that says you can't conceal carry in the office. But when you're out showing property, when you're doing an open house, if you have your concealed carry permit, absolutely. If you don't have your concealed carry permit, then I recommend that you have something. May that be a mace or, whatever, just to have something on hand. And guys, remember, in certain circumstances, anything can be used for a weapon. So at the end of the day, we want you to get away, to get home that night. I think every single one of you on this call, gentlemen, you as well, I think every single one of you should take a self-defense class. You can contact your local karate studio, various places. You see banners sometimes that offer a self-defense class just to give you some basics on what you may need should you ever find yourself in a situation when you get away. Guys, there is no amount of commission worth your safety. And if you don't believe me, when we go to break in just a second, why don't you ask your family members? Because I'm sure they will agree with me. So make sure that you always have safety first and that you're conducting your business. I mean, at the end of the day, I want to come home and I want to have dinner tonight with my husband. And that's what it's about. And there's no commission that should deter from that. So let me open it up. What do you guys think? What are your thoughts? What did you see from the video? What did you thought about before? How do we feel about all this? Too soon? I get that. When I do an open house, it's funny to think about this, but when we do open houses, we're kind of like advertising that we're sitting ducks, right? Like I'm telling the whole world, hey, I'm in this big empty house by myself on Sunday from 2 to 4, come see me. I think it's important that we make sure, obviously, safe during open houses. I'm a big fan of safety in numbers. So if you can have a fellow agent sit with you, one of you could take the second floor, one of you take the first floor, but you're together. You can have an unlicensed person do an open house with you, but it's your responsibility to make sure they understand their role at that open house. Is their role to sell that house? No. If you bring your spouse, is that no. So they need to understand going into that, it's your responsibility to make sure why they're there. I do again with showings, you know, I really don't like it when any of you meet a buyer for the first time at a big empty vacant home. I would like you guys to meet them in a public place first, bring them into your office. However, I'm a realist and I know that sometimes that doesn't always happen. So bring a friend with you. You know, when I've had to show property in the evenings, I drag my husband along. He stays in the car. He doesn't get in my way. He let me does my thing. But you know what? Those buyers see him sitting there. They see him in the car. So I am a big fan of safety in numbers when you can. Same thing with the open house. Have your sellers have a conversation with your sellers as well. Because guys, if it's a busy open house, I'm not going to be able to be with everybody and watch what they're doing. So make sure your sellers have, you know, jewelry and little things put up. Prescription medications, don't put them in the medicine cabinet. Don't put them in the kitchen counter cabinets, because you know everybody puts their meds in the medicine cabinet and the kitchen cabinet. So make sure they're doing something with those. Sometimes people come to open houses to scope the place out, see if it's worth coming back later and robbing. So again, have this conversation with your sellers. Valuables, personal stuff needs to be put up anyway, but anything that may cause somebody, give somebody reason to come back, we definitely want to have our sellers protected as well. Good reminder to be cautious always. Always. Remember, you know, I think the one time I was showing property to buyers and my buyers are coming from Raleigh, and I've been with them for a couple months. They usually came up on Sunday mornings to see properties, and I was with them for a couple months. So I knew these guys, I met them, you know, I was comfortable with them. And so we were meeting on a Sunday morning and we pulled up to the house on the street. We parked in the street because we're not going to let ourselves get blocked in when possible. And so we pulled up in the street. We noticed it was a vacant home, and we noticed two people like kind of walking around the front yard. So we got out of the car and I said, obviously there's another showing going on right now. Let's just, you know, give them a minute. So we stood in the street and kind of, you know, how was your week? And, you know, general chit chat conversation. So then those two people came up to us and said, can you show us this home? And I said, well, I'm with my buyer clients right now. Is that fair to my buyer clients to let somebody else tag along in a show? Absolutely not. I said, so, you know, I can't show it to you at this moment, but I can give you my card, or you can contact the listing agent on the sign. He got upset. You're not going to show me this house? I don't understand. Rah, 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 rah. I don't know what those intentions are, but I don't know. To me and my buyers, we had red flags going up all over the place. So he finally walked on. It was all good. We walked in the house to show it. And of course, I locked the front door behind us because I didn't know where he was. I don't know if he was genuinely interested in that house. I don't know if he was up to no good. I don't know. But what I do know is I was with my buyer clients. It's not fair for them to allow somebody else to tag along. And I had to look out for all three of us. Does that make sense? So we got in, never saw the guy again. It was all good. But you just don't know people's intentions sometimes, you guys. So please, 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 please be safe. Always be safe. Question comes in, could you recommend as a listing agent, while going through the listing and showing potential buyers the property, have cameras on outside with no audio? Yes. So it's not uncommon for sellers to have cameras up. I mean, they're inviting strangers into their home, you know. The buyer's agent needs to be responsible for the buyers. We can't let the buyers run them up through the house. There's videos of buyers allowing their kids to jump up and down on the bed. Guys, let's be respectful of the fact that we are in somebody else's home. Let's follow their instructions. But as far as cameras in the house go, sellers are welcome and often do have cameras. What they can't have or shouldn't have is audio. And cameras don't belong in places where we expect reasonable privacy. So for example, the bathroom, there shouldn't be cameras in there, which is another good reason not to keep your meds in the medicine cabinet. But yeah, it's not uncommon to go see a home, show a home, and see a camera somewhere. Sellers are protecting themselves. Again, what they can't have or shouldn't have is audio. If you were selling your home, would you put some cameras up? You had a bunch of strangers come in your home, would you put some cameras up? It's 2023, y'all. Let's conduct our lives as if we're on camera, because you know what? There's a really good chance that we are. Anything else on safety? It can be deep, I know. I hope I put some thoughts in your head. Again, I don't want to scare anybody. I just need to make you aware of the fact that you need to be careful. I need to make you aware of the fact that you're opening yourselves up to the public. And I'm sorry, but there are some crazies out there in the public. So I need you guys to be safe. This is why we need to encourage you, once you get started, to set up some safety protocols, and you follow those protocols every single time. The last thing you guys need is somebody saying you discriminated against them because you treated them differently with your safety protocols. So you can't say, well, I'm not uncomfortable with women, but I am with men, so I'm going to make men do something. What we do for one, we do for all. And that includes our safety protocol. Anything else? So we're going to take a break. When we come back, we're going to Kahoot, our last Kahoot. We're going to Kahoot on our license, law, and commission rules. So get your phones. And then we're going to talk about our rule exam expectations and rules. So I need you guys back this last hour for that. So we're all on the same page for next week. So let's take 10. We come back, we Kahoot, and then we do rules. Welcome back. All right, so I am taking attendance. And y'all got your phones? Our last, of course you do, those things are tethered to us, aren't they? Our last Kahoot. This is our license law and commission rules. So this is the state specific section. Well, the comments primarily. So here's your QR code. If you're on the app or the website, you need a game pin. 807-6349. Name, nickname, makes no difference to me. You don't want to play on your phone? Just play in your mind. Anybody that wants to play on your phone? Two more coming in? Me in? All right, let's Kahoot. Oh, one more. We good? Here we go. License law and commission rule, state specific material. Question number 1. Real Estate Commission can take disciplinary action against the license, North Carolina license. Who? Seconds. Against both. Remember, if you have another occupational license and you get yourself in trouble with that license, then that could get you in trouble in North Carolina. You got to report it. Please note this word says may take disciplinary action. Are they going to? I don't know. I have no idea. If you don't report it, are you going to get in trouble? Yes. So that's what the rule says. We have to report it. So if you violate a license law or commission rule, or also if you get yourself in trouble with your other occupational license, may that be a real estate license in another state? Questions? See who got it right the fastest. Jay came out fast, followed by Joe and Taylor, Dee Dee, and Nana. Question number 2. A real estate license must be renewed no later than every. Seconds. We renew. Good job, guys. June 30th. The renewal period is May 15th and June 30th. And what do we do during the renewal period? What's our action? Giving them some money. The renewal period is giving them some money that keeps our license current. May 15th to June 30th. Questions on this one? See how we shake things up. Joe's on top now. Taylor climbed up. Erica's on the board. Peter's on the board. Dee Dee's still on. Question number 3, what is the deadline for CE? Six seconds. CE is June 10th. We have to complete our CE by June 10th. June 10th every year. 18 months from licensure is how long you have to complete post. It's a lot of dates, I know. 18 months to complete post. June 10th is the CE deadline. License needs to be renewed by June 30th. Questions? Taylor and Joe are toggling back and forth. Erica's still on. Katie's on the board. Peter's still on. Me is the highest climber, up 5 places. So good job, me, or you, however you want to see that. Question number 4. In North Carolina, real estate brokers must, all real estate brokers must. Seconds. All real estate brokers must include the firm's name and a property for sale. If you don't have the firm's name, it's a blind ad. Who can tell me what's wrong with the blue one? What's the word current mean? Current has everything to do with paying the fee. It has nothing to do with education. Do you see how they like to trick you? See, Kahoot isn't just for fun. Kahoot's also hoping we make this mistake only one time, and let's make this mistake now and not on the test. When you see that word current, I need you to have flags go up. Current means you've paid the fee. It has nothing to do with education. See what they like to do? That's them. Questions on this one? So now we got Erica's on top. Katie came up. Taylor's still on. Peter and CGB are on the board. 5 of you are on fire. You have an answer streak of 3. Question number 5. Under license law, a provisional broker is authorized to. Ten seconds. Good job, you guys. What can a BB do? You can list a property for sale as long as you are under the direct supervision of a broker in charge. Nobody, no licensee, I don't care what your category is, no licensee can sign a sales contract on behalf of your client. We can only get paid directly from our firm, not from the principal. And as we just said, when we advertise properties for sale, we need to include our firm's name because it is their listing. They allow you to work their listing. Questions on this one? This is a good Kahoot. I like it. So we got Erica staying on top. Taylor came back up. Peter's up. Katie and CGB are on the board. 5 of you are on fire now with answer streaks. Last one. How long from receipt does a provisional broker have to deliver trust funds to their bid? 10 seconds. How long do you have? Provisional brokers cannot walk around with somebody else's money. So if you are handed money to hold, get it immediately to your broker in charge. The 3 days of receipt, the 3 days of contract formation, that's how long the escrow agent has to deliver. They have 3 banking days from receipt or contract formation, whichever one happens first. Thank you, everybody, for not saying the green one. I would have been really concerned if we saw that. So thank you guys for that. So the provisional broker, guys, as a PB, if you're handed somebody else's money and asked to hang on to it, when you're handed money, you got to get it somewhere. And if it's not ready to go into an account, you let your BIC hang on to it. Because as a provisional broker, you cannot walk around with somebody else's money. Questions on this one? All right, let's see what we got. Third place, I got Katie. Second place, we have Taylor. And then our first place Kahooter, this Kahoot is Erica with her little crown. I got fourth and fifth runners up, Rosie and Joe came up fourth and fifth place. So that's our Kahoot. Questions? Just a couple quick reminders. The online learning system under the Julie folder is an end of class exam review. I really do hope you guys spend time with this weekend to help prepare you for your test on Tuesday. This is the material you can expect to see on your exam on Tuesday. This also covers the retake. If you're eligible for the retake, you can still look at this end of class review. It's a different test, but the content, I mean, there's only so many ways we can say agency, right? So it's a different test, different questions, but this review covers both. I'm going to talk about the retake in just a second. So the end of class exam review is under the Julie folder, formerly known as the Campbell folder, and the online learning system. Also, as a reminder, you got your cram course on Saturday with Jane. I think this is a great opportunity for you guys to help you guys put it all together. This is not required. This is not mandatory. You can come if you want, don't come if you don't want to. If you can only come for 30 minutes, then come for 30 minutes. Lane is going to email you guys Jane's Zoom link tomorrow morning. So please be on the lookout for that email from Lane. Check your spam. Sometimes Lane winds up in your spam. So be on the lookout for the email from Lane. Even if you're not coming to the cram course on Saturday, I still need you guys to be on that lookout from the email from Jane. I'm sorry, from Lane. I get my Lanes and my Janes mixed up. That's hard, by the way. Even if you're not coming to the cram course on Saturday, I still need you to be on the lookout for the email from Lane with Jane's Zoom link, and I will tell you why in just 1 second. So Jane's doing your cram course, completely optional. You cannot use the cram course to make up time. I do encourage you guys to come. I think it's going to bring home a lot of points. You know, Jane's saying the same thing I am, but she just might say it differently to help things click. Because right now we're trying to put it all together, aren't we? I mean, we're trying to put it all together. So I think the cram course can assist with that. So I do encourage you to come if you can. Jane will look forward to seeing you guys on Saturday. Also, again, the 100%, where are we? The 100%, there's cumulative exams in here. So there's the class marker exam. This is through the same program that you're going to take your test on Tuesday. So this will not only give you insight on how you're doing, but it'll also give you practice on working this program. There's a couple flat PDF quizzes. So there's a practice final exam. There's a national, a state. There's all sorts of stuff under this 100% material. And then don't forget page 819 of your textbook. 819 of your textbook has another cumulative exam there as well. Good question comes in. Will Jane record the cram course? I don't know. I don't know if she will or not. But what I do know is there is a recorded cram course already in the online learning system under cram. So if you look at cram, you have a recording with some notes. No, it's the same test. So the question comes in, can you do the class marker exam? Is it a different, it's the same exam over and over and over again. You have the option to take it as many times as you want. But guys, please understand, you're not going to see those test questions next Tuesday. It's meant to practice. So you can study the class marker exam review, right? But it's, you know, it's just helping you identify your areas of weakness. Are we allowed to log into the cram but not have our cameras on? Absolutely. We're not going to take attendance. You can have your camera off. It's not required. So there won't be attendance. It's completely optional. So there's that and that. Formulas. Formulas are exam. We've scattered all throughout. We have our PowerPoints here. You can find all the formulas here. There's also formulas in the end of class exam review. So remember, whatever test you're preparing for on this class, the end of class exam review, I should say, the formulas that you can expect to see on the end of class exam are found in the end of class exam review. Additionally, you guys don't forget, there's a nice tool, a nice gift for you guys in the online learning system under the math folder. Have you guys looked at this math workbook yet? Maybe brush up on some of the sections that you're not sure of. And if you want to know what math to focus on for Tuesday, it's right here on page 1 of the math workbook. So we got several different sources. Look at the math workbook. Look at the end of class exam review. Look at your notes. Hopefully you've been keeping formulas. Please hear me. You cannot bring anything with you to the test. This is not an open book test. You start with blank scratch paper. We'll talk about that more in just a second. So formulas are scattered throughout your book. Hopefully you're looking at those YouTube channels, those YouTube videos, I should say, where we go over some of the math that you're not sure of. By the way, I'm around all weekend, so don't hesitate to reach out to me. If I can help in any way, I'm still here. When you pass the test on Tuesday and you're preparing for your state exam, guess what? I'm still here. I don't go anywhere. So even after we're done on Tuesday, let me know if I can help you. Please, as you're studying for that state exam, don't feel like you're alone. I got you. The last thing I have to say, we had to, due to time, we had to kind of not skip, but put on the back burner 2 units. We have not done units 18 and 16 yet. Now, rest assured, you're not going to see 18 and 16 on Tuesday. Wow, what did I just do? So you're not going to see 18 and 16 on Tuesday. You may have a question from 18 or 16 for your state exam. So what we're going to do, I'm going to go over the rules and expectations, and then you guys are done. You can log out if you want to. At 1 o'clock, we're done. I am going to keep going. I am going to keep recording. So you have the material for 16 and 18 when you're getting ready for that state exam. You're welcome to stay on the call with me, but you're not required to. So you guys make a note when you're preparing for that state exam. How do you get yourself, I'm talking like 1 or 2 points here, right? But how can you get yourself 1 extra point? Make yourself a note to look at the recording from today's class for 18 and 16. So I will stay on the call after 1 o'clock so we can cover that material, and you guys have it available when you're ready to study for your state exam. Is that fair? Is everybody good with that? If you want to stay, great. If you don't, you'll be welcome to go once we're done with the rules and expectations. Questions or comments about that? On test day, that's all we're going to do is take a test. So we have nothing else left to cover for your exam on Tuesday. I'll talk about exams and just, yep, we're getting there, Caitlin, hang on. I'm getting ready to talk about it. I'm getting ready to talk about all of it. Oh, after class, no, I'm done with attendance. Once we talk about rules and expectations. So if you want to turn your camera off and stay, I'm not keeping attendance. As far as I'm concerned, when we're done with rules and expectations, we are done. But I do want to provide you with the material you need for your state exam, that extra test question. Anything else? I do need to stop sharing this for 1 second while you guys are thinking. So what can we expect to see on, let's see. Yep, we're going to talk about that. So without further ado, what's Tuesday going to look like? I need everybody to pay attention, please. Failure to follow the rules and expectations of the exam could result in you losing your test. So I think it's kind of important that we pay attention the next 20 minutes. Also, let me say this. Let me hold off all questions to the end because I know you guys have a cajillion questions about your test. But it's safe to say if you give me a minute, I will cover your questions. So I will open up for questions afterward. Fair enough? Please just hold off on questions for now. You guys feel this guy's pain? I love this guy. I love this guy. Y'all see him here? 2024. Anybody feel his pain right now? Do you feel like this when you're practicing? Could there be 4 right answers? Which one's the best? I don't know. Big announcement I have for next Tuesday. The first big announcement I have for Tuesday. Remember I said Lane's going to email you guys Jane's Zoom link tomorrow? And whether you're coming to the cram course or not, I need all of you to hang on to Jane's Zoom link. The reason being is I'm not available to be with you guys on Tuesday. So I'm going to leave you in the hands of Jane. I'm going to allow Jane to give you your final exam on Tuesday, which means, and everybody listen to me, Tuesday morning, you log on to Jane's Zoom. Don't log on to mine. I'm not available. So when Lane sends that email tomorrow, that email with the Zoom link covers the cram course if you're coming Saturday, but more importantly, it covers your final exam on Tuesday. So Jane will be giving you guys your test on Tuesday. Does everybody hear me? Can I get some kind of acknowledgement? Thumbs ups, something. I don't want you guys in panic mode Tuesday morning trying to figure out why you can't access my Zoom call. So first important thing that we hear is that you will use Jane's Zoom Saturday for the cram and Tuesday morning for the exam. So for your exam, I'm going to cover it. Jane's going to log on. Jane's going to be available starting at 9:15. So your exam Tuesday morning, log on to Jane's Zoom at 9:15 Tuesday morning. And Jane's got to do a quick check-in process with you guys. So I'll talk about that in a second. So we need you guys to log on time so Jane can get through the check-in process. It really won't take her long. She can't begin the exam until she's checked all of you in. So you guys understand Tuesday morning, you log on to Jane's Zoom and then she will check you in. And we ask that you guys please be on time and please be patient. There's 38 of you and 1 of her. So give her just a minute. She'll get through it, I promise. But we just need a little bit of patience from you guys. Give you a minute to take a few big deep breaths before we start that test. Once she gets everybody checked in, then she will put the link for the exam in the chat. So once everybody's checked in, she will give you the link for the class marker exam in the chat so you can all begin at the same time. For the check-in process, Jane needs to see some things like show and tell. Jane needs to see your basic calculator. Can you use your phones on Tuesday? Can you use the calculator on your phones on Tuesday? No. Can you use a calculator that stores formulas? No. Can you use a calculator that has too many buttons? No. This is it, you guys, a basic calculator. So Jane's going to need to see your calculator. You can have a writing utensil, pen, pencil, purple crayon. We really don't care. You're going to start with 2 blank. Note that word blank. 2 blank pieces of paper. Jane's going to want to see both sides, see that they're blank. It needs to stay blank until the exam begins. Once you start your exam, it's your scratch paper. You do whatever you want to with it. But it needs to stay blank until you get that link, until the exam begins. Jane's also going to want to see your space. So for example, if you're on a laptop, you can adjust, you can show Jane your good clean desktop, right? Good clean space. If you're on a desktop, she may have to rely on the honor system. I promise I don't have anything that can cheat. So she needs to get an idea, make sure we don't have formulas taped to the top of your desk, you know, something like that. It's a whole lot of effort, a whole lot of energy to try to cheat. So you know what? Just don't do it. So we want to see your space. We'll let you have drinks, snacks, cough drops, mints, gum, whatever you need. We need to know that your textbook and notebooks are closed kind of off to the side. Make sure that, you know, if they're near you, that you can't access them. We can't have them on your desk. So we need your text notebooks away from you. And then we need your phone off. Is there a difference between off and silent? Yes. So we need your phone off. Again, a lot of this is the honor system, you guys. Preferably, if we know where your textbook and notebooks are, the reason for this is because we do allow you guys to take bathroom breaks. We're not going to have scheduled bathroom breaks, so we're not going to take a break every hour, but we do allow you guys to take bathroom breaks, and we want to make sure that your book is, you know, not in the bathroom. By the way, if that's your plan, remember, you guys, this is an application exam. It's going to be awfully hard to run to the bathroom every time you need to look something up. And even then, you're probably not going to find it in the book, because you got to take what you know and apply it to the test question. Can your phone be in another room? As long as it's off and not easily accessible. Again, this is a lot of honor system. So Jane's going to do a quick one-on-one check-in with you guys, see your space, check out your areas, make sure we're good. 2 pieces of scratch paper, and please just come with 2. I know you may need more, and we will let you get more, but I need you guys to start with 2, because how many do you think PSI Testing Center allows you to start with? 2. So remember, we're preparing you for that state exam. Okay, so you start with 2. If you want more, we'll let you get more, bear with me. Questions on show and tell. Questions on what Jane needs to see to get you guys checked in. And she needs to see you guys during the test. I need you front and center in your cameras. If we're looking at ceilings, if we're looking at walls, we can't know that you're not cheating. So we need to see you guys. Some of you have virtual backgrounds or the blurry background. Please turn those off for the exam. We need to make sure there's nobody behind you talking to you and giving you answers, right? So we want to be able to see your background. Some of you are in dimly lit space in which it's hard for us to see you. So please just be in a well-lit space. Here's the deal, you guys. The Real Estate Commission says if we suspect you of cheating, we're supposed to take your exam right then and there on the spot. So please don't give us reason to suspect you. Is that fair? That's, you know. So we need to be able to see you at all times, not your ceiling or your wall. You're going to have 2 tabs open on your computer. You're going to log on to Zoom, and then you're going to close your email. So when Jane's checking you in, the only tab you should have open is Zoom. Once she gets everybody checked in, she'll give you the link for class marker, and now you only have 2 tabs open. You guys don't need to watch each other. Once you start that exam, you can minimize your Zoom and kind of tuck it off to the side. I will show you in just a second because Jane won't be sharing her screen. So you're not going to be looking at her screen. I want you guys focusing on the test, not on your peers. By the way, Jane will also have somebody with her. Katie is kind of our back-end admin person here at the school. So Katie's going to be on the call as well, helping Jane. Jane and Katie watch you guys. You guys focus only on your test. So what if? What if you need to go to the bathroom? What if you need another piece of scratch paper? What if you need to adjust the temperature? What if you need to get some water? What if? If you're going to leave your camera for any reason, I need you to communicate with Jane via direct message. If you're going to leave your camera, are you guys here? Oh gosh, I thought I lost you for a second. Okay. If you guys are going to leave your camera for any reason, I need you to communicate with Jane via direct message. Jane, BRB. Jane, I need to get another piece of paper. Jane, I got to get some water. Jane, it's cold in here. I need to get a sweater. I don't care why you're leaving your camera. We're fine. We just need to know where you are. So when you leave, if you need to leave, you need to communicate with Jane. And this is important. You are to never, ever, ever unmute yourself for any reason. During the exam, Jane is your only friend. If she's the only one that you can communicate with, and the only acceptable method to communicate with her is via direct message. Unmuting yourself, you're going to distract others. I know a lot of you have worked really hard for Tuesday, and I'm doing everything in my power to eliminate your distractions. So you guys never, ever unmute. All your communications with Jane via direct message. Unfortunately, if Jane needs to communicate with you guys, the only option she has is to unmute. But that usually isn't much, usually doesn't happen. So whatever you need during the test, are you having a problem with the exam? Do you need paper? Do you need to go to the bathroom? It's all good. We just need to know. So how do you position your camera on yourself in your space? We just need you to position your camera on yourself. Once Jane checks you in, she just needs to be able to see you. You stare at the screen, Jane stares at you. So she gets everybody checked in. She's going to give you the link. She's going to put it in the chat. You get 4 hours. Your clock starts when you begin your exam. You have, as you guys know from your midterm, you have a little countdown clock. So you can keep half an eye on that. Passing 75%. I'll say more about that in a second. And again, as you guys know for the midterm, when you hit submit, it says, are you sure? And you say yes, boom, there it is, pass or fail. Once you see your results, you're welcome to log out of Zoom. When you're done, you're done. You don't have to hang around, wait for everybody else. So once you see your results, additionally, afterwards, you will get an email that gives you the breakdown of how you did in each unit. So when you're done, log out. Jane puts the link in the chat. You click on the link and you get something that looks like this. This is just saying you're not going to cheat. You're not going to use books or notebooks, electronic devices or methods, assistance from anybody else. Any student will receive a failing grade for the entire course and will be reported to the North Carolina Real Estate Commission for further inquiry. So I need you guys to read this and acknowledge again, the commission says if we suspect you of cheating, we are to remove the exam from you right away. You remember from your midterm, you get 1 question per screen. You can go back and forth, forward or backward. You have the opportunity to bookmark a question. So if you get to a question you don't know, or it's a math, for example, you can bookmark it to go back. Each page has a link that says see all questions. When you click on see all questions, it tells you whether or not the question's answered, unanswered, or bookmarked. Before you submit your exam, please click on see all questions and make sure every single one of them says answered. So the last thing you do before you submit is make sure everything says answered. And then, as we said, there's a countdown clock. So you can keep half an eye on your clock. Some of you, the clock stresses you out. So maybe you can bring a little Post-it piece of paper to put over the clock so you don't have to stare at it. But you may still want to keep half an eye on it so your time doesn't run out. Hopefully you've been practicing with a clock, so we're familiar with that. Passing is 75%. So when you pass, Lane will be in touch. Give her a minute. Give her a minute. Please be patient with Lane. So when you pass, Lane will be in touch as soon as she can to send you your certificate of completion. Your certificate of completion is the last piece that you need to submit your application for the state exam. When Lane sends you that email with your certificate of completion, if you're not ready to go to the state exam right now, that's fine. But make sure you keep that email from Lane, because if you don't need it now, you will need it later. So put it in a safe place, put it in a safe folder where you can access it when you are ready to submit your application. And like I said, sometimes Lane winds up in your spam. I don't know why, but sometimes she does. So once you pass, if you don't get the email from Lane, just check your spam before you reach out to her. But guys, give her time. There are 112 questions on your exam. So you need 75% of 112 questions. So if you pass, when you pass, Lane will send your certificate of completion. This is the last piece you need to submit your application. If you do not pass, but you make at least a 50%, you are eligible for the retake on Thursday. If you're eligible for the retake, Lane will be in touch. So if you're eligible for the retake, look out for an email from Lane. If you don't make a 50%, then you are not eligible for the retake, and Lane will send you an email encouraging you to sign up for the next class. So what I'm telling you guys is, one way or another, Lane will be in touch with you after your exam on Tuesday. Pass, eligible for the retake, or less than 50%. Lane will be in touch. So be patient and be on the lookout for her emails. So what if? What if we lose power? What if you lose internet? What if anything goes wrong during the exam? Breathe. Remember to breathe. And guys, know this. I don't have a crystal ball. I can't tell you what, if anything, may go wrong during the test on Tuesday. But what I do know for sure is we will get through it. If you lose power, we're not going to penalize you and say, oh, too bad, you lost your chance. Please understand that we are reasonable people. So if something goes wrong on Tuesday, just reach out to Jane or Lane. Reach out to one of us. And I'm telling you for a fact, we will get through it. I've had students lose power. I've had students lose internet. And guess what? We got through it. So I'd never want you guys to worry that it's not your fault if you lose power, is it? It's not your fault if you lose internet. Some of you do not have a stable connection. Some of your internets have been in and out this entire class. You may want to consider going somewhere, finding somewhere. But if you do, why aren't you breathing? I'm telling you guys, it's okay. We will get through it. Like I said, we're reasonable people. I got some tips and tricks I want to offer you guys, but before I do that, let me open it up for questions. What other questions do we have with Jane for your exam on Tuesday? Does the exam save your answers? Once you hit B and you move to the next question, it's going to keep B. What it's not going to have is the bookmark or the unanswered. So make sure you select something. Never leave anything blank. If you got 10 minutes left and you got 5 questions unanswered, just go through and put B in real quick. At least you got a 25% chance of getting it right. Or C or D or A, whatever your favorite letter is. I know a lot of you are new to online testing. I know a lot of you are new to online testing, but guys, Carolina School of Real Estate, we've been doing this for, well, 3 years now. If you lose power, we will get through it. Jane can do a restore link that can send you the link that you can pick up where you lost power. You're not going to lose those answers. We will get through it. Please rest assured with that. I hope that alleviates some concerns, some nerves. You can go back and forth. So if you want to go back to a question, yes, 1 question per screen, you can go back and forth. Some of you may want to take the class marker exam in the 100% material just to kind of refresh what class marker looks like. Remember, there's a class marker tutorial in the email from Lane. So if you want to see what it looks like, if you want to practice with it, we make that available for you as well. Again, we try to alleviate as much stress as we can. If you're new to it, we're not. I don't know how many times we've done this in the last 3 years. We got it. Okay, can I offer you some tips and tricks for Tuesday morning? The number 1 piece of advice I have to offer you, and I'm watching some of you not do it right now. The number 1 piece I have to offer you Tuesday morning, breathe. Everybody just breathe. Big, deep breath, please. If you see a test question, oh my God, I've never seen this before in my entire life, stop and take a big, deep breath. Get your breathing level, get your breathing centered. You're going to think better. You're going to feel better when you have good breath. So the number 1 piece of advice I can give you for Tuesday is breathe. The number 2 advice I can give you for Tuesday is read. Read the question. Every single word means something. Read the answer choices. Every single word means something. So breathe and read. Read and breathe. On Tuesday, once you answer something, do not change your answer unless you are 5,000% sure that it's wrong. Come on, guys, it's time to be honest. How many of you have changed a right answer to wrong because you second guessed yourself, you doubted yourself, and you had it right, but dang it, you went back and second guessed it and you changed your answer? Stop it. Stop it right now. Once you answer a question, move on. If you know you answered it and you were sure you answered it, why are you going back to it? The only ones you should be going back to are the ones that you bookmarked or the ones that you skipped. So do not change an answer unless you're absolutely sure. Like we said, make sure you have answered any skipped questions. Go back through the see all question links and make sure everything says answered. I also recommend that you guys bookmark the math and save it for last. The math is going to take you the longest. So when you see a math problem, just bookmark it. Don't even read it, just bookmark it. And once you've answered everything else, then go back and tackle the math, because now you know how much time you have left to do that. So always save the math for last to make sure that you have enough time. Speaking of time, I want you guys to take your time to read each answer, to read each word, to read each question and answer, but just make sure you're watching your time as well, because at 4 hours, class marker cuts the exam. That's out of Jane's control. So the system cuts the exam. And again, if it's unanswered, you're not going to get credit for that. So let's talk about Monday and Tuesday. How many of you are taking Monday off? I'm just curious. Does anybody have Monday off and your plan is to study for 24 hours on Monday? Okay. All right. Let's talk about what that means. Between now and Tuesday, I don't need you guys to spend all your waking hours studying. There is such a thing as overstudying. Between now and Tuesday, I need you to put the book down at some point. Go get some fresh air. When you overstudy, if you stay up all night, Monday night studying, and you come to the exam Tuesday morning, you're over it before it ever starts. So give yourself some time this weekend. Of course, I need you guys to study this weekend. Of course, I want you to study Thursday, Friday, Saturday, Sunday, and Monday. But that can't be all that you do. Give yourself a break. Go to lunch, go for a ride, go do something. Everybody with me? At some point Monday night, I need you to close the book and put it down and go do something that relaxes you. At some point Monday night, you've got to put it down. You've got to know that you know what you know, you know? So at some point Monday night, put it down and say, this is what it is. Because I need you guys. What's mama say? Mama says, get a good night's sleep. Don't try to stay up till 5 o'clock in the morning. Think you're going to take a nap, then come take that test. And I need you guys to eat a light meal. Get you a little something on your stomach so you're not listening to that grumble. Don't go to Golden Corral and hit up the buffet. Now you're sleepy, right? So get you something on you. Go get you a biscuit or something. Get you something light on your stomach. Again, if you need snacks, we'll let you have snacks. That's fine. Breathe and read. Read and breathe. I worry about some of y'all. I watch you hold your breaths. I watch you. I see it. Or these short little labored breaths. That's not what our brain needs, is it? Breathe and read. Big, deep breaths. In through the nose, out through the mouth. Guys, bottom line, we all wish you the best of luck. Encourage you guys to pursue this career. It's an amazing industry. I wouldn't have been here for, I'm on year 22 if it wasn't. There's a lot to do. There's a lot to learn. There's enough that's kept me busy for the last 22 years and hopefully for the next however long before I retire. So this is just the start of it. And we wish you guys the best of luck, not only for your exams, but as you get into post-licensing, as you start affiliating with firms and start using that brand new license that you've worked so hard to get. The last thing I have to say, in addition to your exam results, in addition to hearing from Lane, all of you are also going to get a survey link from her. I encourage you guys to take the time and provide your feedback. Lane and myself love to hear from you guys, your thoughts. It's anonymous, so if you're worried about hurting my little feelings, you don't have to worry about it, but we would rather you guys be honest because that helps us grow. Your constructive feedback helps us grow. So any thoughts or suggestions or recommendations, anything you guys have to say, I encourage you to be on the lookout for that survey from Lane and let us know. Okay. What questions do I have? This is it. Here we go. Let's see. We're going to get all the links in our email on Friday. Yes, Lane is going to send you an email tomorrow morning, and that email is going to have Jane's Zoom link. And you need Jane's Zoom link both for Saturday and for Tuesday morning. So whether you're coming to the cram course or not, I need you to be on the lookout for that email from Lane tomorrow because that's your access to the exam Tuesday morning. I do hope everybody heard me. Is it divided in national and state or just the whole test? So my end of class exam does have 2 sections, national first and then state, but it's 1 grade. So they do specify you're in the national section and you're in the state specific section. $112 questions. Well, guys, as far as I'm concerned, we're done. I appreciate you guys. Again, I wish you guys the best of luck. If there's anything whatsoever I can do to help you, I am here. Even though we're done, we are not. So please never hesitate to reach out to me. Let me know if I can help, not just you getting ready for my exam on Tuesday, but for your state exam as well. Study group link. Somebody's asking for that. If somebody can provide that for Joshua in the chat to everyone, I would appreciate. Again, if you guys want to go, you're welcome to go. If you want to stay and hear 18 and 16 live and in person, you're welcome to. Whether it's just me, I'm going to keep going and cover that material so you have it for your state exam. Thank you guys. It's been good. And I look forward to seeing you guys in post licensing. That's what I like to see next, are your faces in post. You know what comes after post? We get to do a deal together. Isn't that fun? Or you get to do a deal with one of my teammates. So when you guys see us come across, you're like, hey, good, good. I know, last day, where'd the time go? Yes, I'm going to still record. So I'm putting today's class on our YouTube channel so you can access it for your state exam. If you need the YouTube channel, please reach out to me today. I hope you all have it by now, but if you need it, just reach out to me today. Good luck, everybody. Thank you, guys. Study, study, study. But don't study too much. It's a balance, isn't it? It's that balance of studying too much versus not studying enough. Anything else on this? So I need to stop sharing this for 1 second. Again, you guys are welcome to stay around. I'm officially done taking attendance, so this can't count for you or against you. So I just need to pull that PowerPoint back up. 18 and 16, I mean, these are going to take us like maybe an hour, hour and a half. We're going to go through them pretty quickly, but we do want to cover the material. So 18, the hat that we get to wear in Unit 18 is our accountant's hat. So we're going to get just a basic understanding of what may or may not be tax deductible when it comes to owning or selling real property. So as soon as my PowerPoint comes up. So 18, here we go. So Unit 18 is our federal income taxation and our real property ownership. Any of you accountants? Any of you CPAs? No. Okay. So guys, understand, we can't give tax advice. So if your buyers or sellers have tax questions, we need to refer them to an accountant. Some of you may do your own taxes on TurboTax. Do you know what kind of expert that makes you? None. So please make sure your buyers and sellers ask about any tax advice that you're referring them to an accountant or a CPA. So really the two things in this unit, we're going to identify the different tax benefits of homeownership. There are some deductions that you might be eligible for as a property owner. There might also be some deductions when you go to sell the property. So we're going to make you aware of those. And then I know that word says calculate. We're not really doing math, but we're first going to define those words, and then we're going to put them in formula. So we're not going to do the math, but we need to understand what those words do and how they work. So some of you are vocabulary people, so we'll define the words. The rest of you are formula people, so we'll provide you with both just so we understand. So there's two different tax discussions to have in this unit. And the first one is tax benefits for people that own a property, personal residence owners. And as a residence owner, you might be eligible for some tax deductible expenses. The interest that you pay on your mortgage might be eligible for a tax deduction. Loan discount points. What do we remember loan discount points are? Discount points are prepaid interest. So the year you buy your house, you're paying some of that interest, right? So the year you buy your home, those discount points may be a tax deductible expense. Yeah, of course, just don't drive. Your prepayment penalties, if your loan has a prepayment penalty, then that may be a tax deductible expense. Your insurance, anything you pay for your loan origination fees. Again, these may all be tax deductible expenses. Some of you may be having questions right now about your own ownership. I can't answer that. If you have questions, if something just brought to your attention, call your accountant, reach out to your accountant, and they can help you determine what's tax deductible and what's not. The other thing that might be tax deductible year after year after year are the property taxes that you pay. So each year you pay property taxes. That may be a tax deductible expense. Again, just contact your accountant. They can help you identify what is, but there are some good benefits to being a homeowner. So that's one piece of this unit. Questions on this piece? The second piece of this unit is tax considerations when you're selling your property. So there might be some benefits when you're selling. Let's define some words on page 464 over to 465. Capital gains is the amount you realized from the sale. Capital gains is how much you earned when you sold your property. Again, we're going to put these words in formula form in just a second for those of you that have that math brain. So capital gain is just the amount realized once you sell your property. Cost basis is the owner's initial cost. So cost basis says this is how much you paid for the property back in the day when you bought it. That's your initial cost. So the cost basis is going to be the sales price plus any of your closing costs. What did it cost you when you bought the property? Capital improvements are improvements that you make to the property while you own it that add value. Capital improvement adds value. Painting a room does not add value. Finishing the unfinished basement adds value. Building a room on the back of the house adds value. So if you did anything to add value, that's your capital improvements. Your adjusted basis then is your cost basis plus your capital improvements. So your adjusted basis consists of what did you pay for it back in the day, plus what capital improvements did you make on it while you owned it. So your adjusted basis. And then again, your amount realized is basically the difference in what did you buy it for versus what did you sell it for. Your amount realized, what's your adjusted basis compared to what you sold it for. You'll see this in formula in just a second. So different tax considerations when selling property. Honestly, it depends on how long you've owned the property. For taxation purposes, ownership is broken down into short-term ownership or long-term ownership. Short-term ownership is for anything less than 12 months. So if you own a property for 12 months, it's considered short-term. And when it comes to short-term ownership, you're not going to get the tax benefits when you sell it. You're only going to get these tax benefits as a long-term owner, anything more than 12 months. Who typically owns a property for less than 12 months? Typically. There's exceptions to all rules, but typically, who owns the property for less than 12 months? See Will's turning. Yeah, that's it. Our flippers, our investors, are people that come in, buy the home, flip it, turn around and sell it. Guys, those investors, they're not eligible for tax benefits because they get their tax benefits as part of their ordinary income. That's what they do for a living. They buy a house, they flip it, and they sell it, and those tax benefits are rolled in. So these tax benefits we're referring to are just the long-term ownership more than 12 months. So in order to qualify for these tax benefits more than 12 months, The property needs to be your principal residence. It needs to be your number one. You may have a vacation home or a second home, but this property is your number one. The tax benefits that we're talking about, if you're a married couple filing jointly, you may be eligible for tax benefits up to $500,000. I will talk more about that in just a second. If you're single or you're married filing separately, your tax benefits can be up to $250,000 tax-free. Again, we'll look at those numbers in just one second. And then the other thing to qualify, you need to have occupied the home 2 out of the last 5 years. Those 2 years don't have to be consecutive. You can live here, 6 months, as long as your period in the last 5 years equates to 2 years. Again, go to your accountant for further information. So now if we take those words that we just learned and we put them in formulas, again, depending on what side of your brain works. To find our capital gain tax, we first need to find our adjusted basis. So our adjusted basis is our cost basis, also known as our purchase price, and our closing costs. Purchase price plus our closing costs together equal our cost basis. Your cost basis, what you paid for it back in the day, plus the capital improvements you made while you owned it, are your adjusted basis. So your cost basis plus those capital improvements gives you your adjusted basis. Now fast forward when you go to sell the property. Your sales price minus your allowable closing costs gives you your amount realized. What did you sell the property for? So the adjusted basis looks at what you pay for it and what you put into it. Your amount realized tells you what you sold it for. It's the amount that you realized as the sales price minus closing costs. The difference between the two gives you your capital gains. So if you sold it for more than what you pay for it and added to it, you had capital gains. If you sold it for less than what you paid for it, less than what you put into it, then you have a loss. You might be able to claim that loss. I don't know, talk to your accountant. So the capital gains, all it is it's comparing what you paid for it back in the day, what you put into it while you owned it, compared that to what you sold it for. And those are your capital gains. So let's look at something in practice. Y'all put your pencils down. Put your pencils down. Let's look at something in practice. So say you bought the property for $398 and you had 1,550 closing costs, no capital gain or capital improvements. 20 years later, you sold the property for $920,000 and you had closing costs. So back in the day, what you paid for it plus your original closing costs gave you your cost basis. Had you had capital improvements, then it would be your adjusted basis. Now fast forward to when you sell it. You sold it 20 years later for $920 minus your allowable closing costs. That gave you your amount realized. The difference between the two is your capital gains. In this case, there's capital gains of $519,850. So what does that mean? They're going to charge you taxes for your gain. You see, gain, you made money, right? So they're going to charge you taxes. And that's how they know your taxable amount. That's how they know how much to tax you. So let's say we said your capital gain is $519,850. You're a married couple filing jointly, which means you have a $500,000 tax exemption. That's that 500 or the 250 for single, filing separately. So now, instead of paying taxes on $519,850, they're going to let you take this $500,000 tax exemption and only pay capital gains taxes on $19,850. Is that better? There we go. That's what that 500 and that 250. So now your taxable capital gain, assuming, I don't know, I'm not an accountant, but assuming the tax rate that year is 15%, then your tax bill for the year would be $2,977.5, much better than 15% of $519,850. So yet another good reason to talk to your accountant. Questions? The rest of Unit 8 just kind of gives us some special rules for accountants. If you have a home office, I mean, honestly, since pandemic, a lot of us have home offices now, don't we? And that home office may be eligible for tax deductions. Talk to your accountant. There's certain rules. You guys see my tax deduction, this little corner back here of my office. Yeah, this is my tax deduction because it's all work that happens back here. So this is the part of my home that's eligible for my home office. There's certain rules or certain requirements. So again, just make sure you get with your accountant, because you might be able to write off not only a portion of the space, but I mean, don't I need power to conduct my business? Don't I need internet to conduct my business? So a portion of that stuff can be written off as well. Not all of it, but a portion of it. Another thing that might be eligible for some tax benefits, something worth talking to your accountant, is installment sales. We talked about installment contracts back in Unit 10. I remember in an installment contract, the buyer's paying the seller, but they're not paying the seller everything at once, the whole purchase price at once. They're paying the seller in installments. And as that seller receives those installment payments, those payments might be eligible for some tax deductions. And then the other thing is, if you have a vacation home or you're helping a buyer buy a vacation home, there could be some benefits for vacation properties. They might be able to write off certain expenses for the vacation home. Again, there's some rules with that. Like, for example, to get benefits for your vacation home, you can't live there more than 14 days out of the year. So you own the home, but you can only go for 2 weeks. If you want to get tax benefits, that means the rest of the time you got it rented out. It is somebody else's vacation. So if you have a vacation property, you may want to talk to your accountant, see if you qualify. Another thing available by the IRS, and this one is nice. If you're an investor, or if you're an agent working with investors, the IRS has a program called the Tax Deferred Exchange, also known as the 1031. Again, this is for investors only, no principal residents. But what the 1031 allows the investor to do is to sell their investment property. If they use the proceeds of the sale of that property to buy another investment property, then they don't have to pay capital gains taxes. Isn't that nice? They can defer paying their taxes. As long as we're using the proceeds of the sale of this investment property, as long as we're using it to purchase another investment property. And there is no end. They can keep doing that until they sell their very last investment property. Isn't that huge? I mean, that's great for investors. You're just defer paying your taxes because you're transferring it from one investment property to the next. This says like kind exchange. understand for the IRS, they consider real estate for real estate. So it's not like you have to sell a condo and buy a condo, right? If you sell a condo, you can use the proceeds to buy a single family home investment. It's real estate for real estate. So again, if you're an investor or if you're working with investors, then you want to encourage them or you to talk to an accountant. Because there are some rules. I think, for example, you have to buy the next investment property within like 6 months. So it's not like you can have it out there forever, right? There are some restrictions. So the accountant can help with that. Accountants also consider depreciation. Depreciation is just the loss in value for any reason. We talked about depreciation a little bit back in unit 17. The accountants may generally depreciate the building over the life. And, just the most common tool that accountants use to determine depreciation is called straight line depreciation. So let's say, for example, that it's determined that the building has 30 years of an effective life, which means the building, the structure has value for 30 years. And what straight line depreciation says, it's going to lose the same amount each year. So let's say, for example, this is a 550,000. The property's valued at 550,000. And we determined the effective life is 30 years. I already lost my calculator. It couldn't have gone far. There it is. 30 years. So 550,000 divided by 30 means each year this building is going to depreciate $18,333. So year one, how much value does it lose? $18,333. Year two, year five, year 13, year 27. Every year for the next 30 years, it loses $18,333. And that's all straight line depreciation is. So that helps the accountant determine the new value. And again, I'm not saying after 30 years, the building's going to fall down. We're just saying it no longer has the value that it did 30 years ago. Boom. That was a 20-minute unit, wasn't it? Short, sweet, and to the point. All right. So those key terms, 463. Again, you guys, maybe a test question or two. Maybe one. Hopefully by giving you guys this, if you need that extra question or two, give you that benefit. That's why we're here. Key point review, I would suggest focusing more on that and the PowerPoints, the recording, and then your student quiz. And remember, page 474. 474, some of the math on page 474 is math that we covered back in Unit 12. So we did investors math in Unit 12. I don't know why it's in 18, but it is. So the student quiz, some of the math. Questions on 18? Don't act like an accountant if you're not an accountant. Don't give out tax advice. Always encourage your buyers and sellers. The first year they own a property, the year they sell a property. Encourage them to talk to their accountant to make sure they're getting all their benefits of being a homeowner. If some of this is if my homeowner's on the call and some of this is brand new information, call your accountant this afternoon or after Tuesday. Maybe that would be better. Call your accountant after Tuesday and make sure you're getting all those tax advantages that you can as well. Questions? Okay. The last unit we have is Unit 16. This is our basic residential construction. Anybody going to be going builder developer route? Anybody heading that direction? Maybe. You'll probably work with builders and developers. I think this unit is good when we're working particularly with buyers. Do y'all think buyers like to point at stuff and say, what's that? And so this unit kind of helps us give us an idea so we can answer some of those questions. Again, we're not in builder school. We're just scratching surfaces and introducing you to some of the basics. And please note, this is just specific to residential construction. Commercial properties tend to be built differently than residential. So our focus here is just on residential. So in this unit, we're going to talk about some basic architectural types and some styles. We're going to look at some basic components, some words involved with constructing, with building and constructing properties. So first off, let's talk about some basic architectural types that we may expect to see. The ranch is very, very popular, particularly around here in North Carolina. By the way, most homes, most residents in North Carolina are wood framed construction. Most residential properties are built with treated wood, because remember, who else likes wood? Or I should say, what else likes wood a whole lot? We want to keep those termites away, don't we? So they're built with treated wood, try to help keep those termites away for a long time. But wood is a good construction basis for residential because it's less expensive and it's flexible. It allows the builder to build with whatever designs and styles that they want to. So ranch is quite popular here in North Carolina. With the ranch, all of your living level is on the main floor. So you got your kitchen, your dining room, all of your bedrooms, your breakfast room, all the main living is on one floor. Maybe you have a basement, maybe you don't. If you do have a basement, maybe it's finished, maybe it's unfinished. You can have a finished basement with like family rec room or something like that, a bonus room. You may have an unfinished basement for storage. But the point of a ranch is that everything is on one level. In a split level, your main living is on the first floor. So your living room, kitchen, dining room are going to be here on the first floor. And then about halfway through the home, you come to an option to either go up the stairs or down the stairs. So if you go upstairs, primarily what you're going to see is bedrooms up here in this level. When you go downstairs, you might have a little below grade space here, or basement space, but usually that's like a finished den, dining room, or not dining room, family room. Don't confuse a split level for a split foyer. In a split foyer, it's a 2-story home. And in a split foyer, you walk in the front door and you have 2 choices. You go up or you go down. Split level does have some main level living. So 2-story homes, again, on the main floor, you're generally going to see kitchen, living room, dining room. You may have a bedroom on the main floor, the primary bedroom on the main floor. Second floor is generally set aside for the rest of the bedrooms, if not the primary. And then the contemporary is a unique design. A custom built builder would be more than willing to work with a buyer on something custom, something contemporary. So in other words, it's going to be rare to find like a subdivision or community with contemporary homes. Usually we have similar designs in a new subdivision. So let me ask you guys what you think, if you want to weigh in. Of these 4 designs that we're looking at, what do you think is the most expensive one per square foot to build? Which one cost the builder per square foot? What do you think? I'm just curious. Ranches, contemporary, yeah, it's hard to tell, isn't it? Contemporary, I can agree with that because it is a unique design. It could be a custom build. So per square foot, could this get really expensive really fast? You better believe it. Per square foot, generally speaking, per square foot, the one that's the most expensive to construct is going to be the ranch. And here's why. The two most expensive components when you're building a house are the roof and the foundation. And the ranch, the entire property is under one roof. The entire property is on one foundation. You may have a 2-story home that has the same square footage of a ranch, but it's split. So now you only have half the roof and half the foundation. Does that make sense? So when we're building per square foot, what's most expensive is the roof and the foundation. And because of that, ranches tend to be, obviously we can get crazy with the contemporary, of course. Bottom line, when it comes to styles, buyers generally have their own preference. You may have a buyer that specifically wants a ranch. You may have a buyer that wants a garage. You may have a buyer that doesn't care how many stories it is, as long as the primary bedroom's on the main floor. So having these conversations with buyers, helping them identify what type of property, what their preference is, helping us having an understanding of these styles to help them see what they need, see what they want when they're buying a home. Questions on any of the styles? So the rest of this unit is just some basic construction components. So again, we're going to go through a very basic, how do you build a house? And we're going to take this picture. You're welcome to take a screenshot if you like, but we're going to take this picture and break it down. We're going to break it down into the different components. So really what we're looking at here is the foundation, the walls, and the roof, the 3 different components. So just like a builder builds from the ground up, that's how we're going to discuss. So the very first thing you do when you're ready to build a house, the builder has to put down footings. Footings are put down by digging trenches. The trenches need to be below the frost line, depending on where you are in the country, depends on how far down your frost line are. The further north you go, the further down you got to dig. It's much more common to find basements up north than it is here. We have basements here, absolutely. But it's much more common to find basements up north because you got to dig deeper, and you dig deeper, you might as well dig it out and have a basement. So we got to get below that frost line. The frost line is what expands and contracts during those extreme cold temperatures. So we want to make sure that the support of the home, the footings of the home, is below that frost line. Once you build it, once you dig the trench, then you use maybe poured concrete, for example, into the footings to give it as basis. And then on top of the footings, you put the foundation. So the foundation rests on the footings. We're going to talk about the different types of foundations next. If the foundation is going to be a basement or a crawl space, you may have piers. You guys see these here, these piers, just to help support the floor and the entire way to the house. If we didn't have these piers, we might have some sagging eventually. So piers just help offer support. The different types of foundations that we may see. Crawl space, we're going to lift the living level above the ground, off the ground. Crawl spaces allow for ventilation. They allow for moisture control. That's this white plastic stuff you're looking at here. That's moisture control to keep the moisture in the ground and not up in the house. But you have more control. You usually can access the pipes, for example. Sometimes the HVAC unit might be in the crawl space. But it just lifts the main living level, allows us to get under control, ventilation, moisture control. A basement is just a story high crawl space. So what's the difference in a basement and a crawl space? The basement is 1 story high. It was dug in that deep that it's 1 story. Again, it lifts the living level. And that's where you may have the finished or the unfinished basement. The slab is just poured concrete directly on the ground. So with the slab, there is nothing that lifts the home. Slab, you pour concrete, and then you build a home on that. Again, sometimes this comes down to buyer preference. Sometimes they want a different type of foundation. I will share with you guys one concern I've always heard about slabs. Before they pour that concrete, before they pour that slab, they have to already have the pipes and the electrical, everything installed. And then once they pour that slab, they are where they are. There are no moving them. So if you want to remodel your bathroom, the sink and the toilet and the shower are here, right? You can't get underneath the house and move the pipes around to rearrange that. So that is one deterrent of a slab that I've heard. But if you don't plan on remodeling your bathroom, then, or if you're fine where the sink is, then that shouldn't be a problem. Crawl space and basement, again, a lot of times the pipes are underneath, so if you want to move them around, access them, you can. So coming up from the foundation, we poured our footings, built our foundation. Then we have some different components. Here's our footing, our foundation wall. The sill is this piece right here. The sill is the lowest horizontal piece of wood. The sill sits on top of the foundation. Girders may go on top of the sill to help balance. We want a level home, at least we want to start with a level home. So girders can help with that balance, help level that out. And then on top of the sill or the girder goes our floor joists. The floor joist is usually a piece of wood, and it offers support to the entire home. Think of all the weight that floor joist has to hold of the home. It forms the structure of the floor. It gives us an idea of what that floor is going to look like. On top of the floor joist goes the subfloor. On top of the subfloor goes our flooring. So whatever you're walking on right now, carpet, tile, laminate, hardwood, vinyl, that is all installed on the subfloor. So our foundation components, basic foundation components. Coming up the foundation into the walls, we have our studs. Studs are what give the home their shape. Studs are usually are vertical pieces of lumber. Have you guys ever heard the sayings, the bones of the home? That's what we're referring to with the studs. Those are the bones. That's what gives us our shape. Today, studs are typically 16 inches apart. Building code says 16 inches apart. If you come across an older home, building codes change over time. So if you come across a home built 100 years ago, the studs may look different. They may be different because they were built in different times. The stud connects to the subfloor with the sole plate. The stud connects to the ceiling with the top plate. So the top plate and the sole plate connects the stud to the floor and the ceiling. I always remember sole plate because it's like, where's the sole of your shoe? That's the bottom of you, right? So your sole plate connects the bottom, the top of you connects to the top. Headers are horizontal pieces of wood that go over openings. So think about window openings, door openings. Headers go over those openings just again to offer support. We don't want that door frame to fall in on you. So there's a horizontal piece of wood over an opening just to help support. Before we get to the roof, there's a couple different types of framing. So back to our studs, a couple different types of framings. Platform framing is the most common. With platform framing, each floor is framed separately. So you guys see I got framing here on the first floor, and then we got the floor, and then we got framing up here on the second floor. So each level, each floor has its own framing, and that's platform, and that's what we see the most common. Balloon framing goes straight from floor up 2 stories. There is no separately framed floor, So balloon flooring goes straight from the foundation to the ceiling, generally in a 2-story home. And then post and beam framing, this is more of like, I always think of like our mountain lodges, our mountain cabins. I always think of a Thomas Kincaid home with post and beams. You can see the posts, you can see the beams. They usually use extra large pieces of lumber, more for decorative purposes. Again, that would be more of a custom, generally speaking, more of a custom built. The stud, I mean, we can see here the studs. We talked about the bones. The studs, another way to think of this, are the skeleton of the home. The studs kind of start to show us the shape, how the rooms are going to be divided. And then from the walls, we move up to the roof. The ceiling joist attaches to the top plate. The ceiling joist, again, is just a flat piece of wood. It helps carry the weight of the roof. I hope you guys are hearing a lot of home construction is about support, is about balancing that weight of the house. Another big part of house construction is moisture control. When it comes to houses, moisture is bad, really, really bad. So a big part of our construction that we're getting ready to see is to help keep the moisture off the home. So the ceiling joist just carries the weight of the roof, connects to the top plate. Rafters are like the triangle members of the roof. The rafters give the roof their shape. The ridge board is the highest part of construction. When you go outside after we're done and look at your house, you look up, you're going to see a ridge board. It's the highest part of your house. Flashing, if you have an opening in the roof, for example, a chimney or maybe a vent, and you have an opening in your roof, you're going to have flashing to help keep that sealed. Again, we don't want moisture, we don't want rain to come in down around the chimney. So flashing is that seal in a roof opening. And then the eave is the overhang of the roof. So it's kind of, you see right here, it's what juts out. The soffit allows for ventilation. It allows to ventilate up into the attic. Again, we're trying to prevent moisture control. If you go outside to your house after class and you stand flat against your house and you look straight up, crank your head up and look straight up, you're going to be looking at the soffit. And you're going to notice there's probably a bunch of different holes in it. And that's what you're looking at is the eave. The fascia runs along the side of the eave. The fascia is what we attach our gutters to. Gutters are meant to drive moisture and water away from the house. So when it rains, we want the rain to run down the roof, into the gutter, out away from the home. Yep, it's all about moisture control. So the gutters attached to the fascia. And then the freeze board may also offer ventilation. A lot of times the freeze board is more decorative. It helps what gives its home its unique look if it does have a freeze board. So again, just very basic components. having an understanding of what these words mean. Any questions on foundation, wall, or roof? Still building our house. Now that we have our studs up, we need to put walls up. So on top of the studs goes sheathing. Sheathing may be particle board, it may be plywood. On top of the sheathing goes tar paper or house wrap. Tar paper is the more, the older way to do it. The more modern way that we're seeing is house wrap. That's what you're looking at right here. It looks like white plastic wrap, and they cut out holes for the windows and the doors. And then on top of the house wrap goes the siding that we see: vinyl, brick, shake, cardboard, stone, stucco. So whatever we see, that's what gives the home its look. Homes have windows. We have a couple different types of windows. Sliding windows either open up and down or back and forth. So you have a pane that moves, it slides. Swinging windows open out. They usually have a crank that you crank them and they open out. They have an awning to protect them. When it starts raining, when you're done with them, you crank them back in and they close. Those are swinging windows. And then fixed windows don't open at all. That's what you're looking at here. Those are like our picture windows. They're more for decoration, help us see the elements. Windows have components. What makes up a window? The window sill is the bottom. The bottom of the window is the window sill. The jamb are the sides. The header is the top. Where's your head? It's up top. So the header is what it's up top. The sash is the panel that moves. So if it opens up and down, that sash is that piece that moves. If it opens side to side, the sash is that piece that moves. Muttons and mullions are not words I just made up. Muttons and mullions are the cross hatches of the windows. Your muttons are your horizontal hatches. Your mullions are your vertical. So the panes, the cross hatches, muttons are horizontal. Mullions are vertical. Homes also have doors. Understand exterior doors and interior doors are different. Your front door is much more sturdy, much thicker, much more secure than your closet door. Your closet door, the door that leads you into your bedroom, those doors are usually hollow. They can be kicked in easily. So the front door, the exterior doors need to have more stability. They're thicker, they're heavier. As far as finishes, a door can be flush, which means it's flat. Panel is what you're looking at right here. They have some indented pieces just for decoration. Usually we see these panel doors inside. Sliding glass doors generally lead into a balcony or a patio or a deck. They open up and you can walk through them. And then your French doors are more upscale decorative doors. Usually they have glass panels, maybe a crystal handle. I think for an example of where we might find a French door might be between the kitchen and the formal dining room, for example. Might lead out French doors, decorative, upscale designs. Good news about doors. Their components are the same as windows. The sill is the bottom. The jamb is the side. The header's up top. Questions on doors and windows or windows? We put our rafters down. Now we need to build our roof. The decking is what lays on the outside of the rafters. It's going to be some kind of particle board, plywood. On top of the decking go the shingles. The shingles generally attach to the roof using some kind of roofing felt. Shingles are generally asphalt or fiberglass. That's the most common. And shingles have to be laid in such a way to allow water to flow down and off. We don't want water to hang around on the roof. We want it to flow away. So you see how these are laid in a certain way. When it rains, they're just going to run right down into the gutters. The gutters are going to pull the rain away from the house. So the decking goes on the rafters. The roofing felt is used to connect the shingles to the decking. And then the pitch is just the slope of your roof. Rise over run. Higher the rise over the run, the steeper the roof. Some are more steep than others. So the pitch is the steepness of the roof. Look on page 428 real quick. 428 just gives us some basic roof design, residential and commercial. Here in this area, the gable roof is the most common, which is that triangle shape that we have with our rafters. We can see hip roofs, which are like indented on four ways, not just this way, but the front and the back as well. Dormers are those little windows that you see on the roof. Sometimes you can walk out on them. Sometimes they're just there for decoration. That's probably the number one things that buyers point at and say, what's that? Are dormers. So we know to answer that question. Salt box, we see that around here a lot too. A salt box is like a 1.5-story house. So you have 2-story in the front and then 1 in the back. It's 1.5 stories. Entire main living level, and then just part of it has a second floor. So that's where we may see a salt box roof. The flat roof is mostly what we see in commercial. So commercial properties have a flat roof. Usually AC units, heating units are going to be up there. Obviously, the concern with a flat roof is drainage. So when these commercial buildings are being built, they need to take drainage into consideration. But again, just a basic understanding of some of our roof styles, roof designs. Homes also need some kind of insulation. Got to help protect the inside from the outside elements. Y'all remember the old insulation, the big Pink Panther bats, and they came in these huge rolls and you just stood there and just basically rolled them out. Well, we've come a long way. You still can find rolled insulation, but some more modern ways to build. What our friend the Pink Panther is doing here is they're blowing in insulation. It's a loose fill. You blow it in and then it hardens, providing that insulation. We may also see foam insulation, same idea. You spray it in, you know, foam's a lot of fun to play with, isn't it? And then it like expands, kind of fills in the gaps. And again, it will harden. So just some different types of insulation materials. Cost is a big thing with what type of insulation is used. Weather stripping is used around exterior doors and windows. Help keep the elements and the critters out. So weather stripping fills in any of those seals around doors and windows. And then, like we said, a big part of house construction is moisture control. So we want lots of ventilation, particularly in the attic, the foundation, the basement. Help keep the home dry, keep the moisture off of it. Insulation is defined as what's called an R value. The higher the R value, the more resilient the insulation is to the elements, to the outside elements. North Carolina Uniform Residential Building Code has minimums. They require at least an R value in insulation of 13 in the walls. They require at least an R value of 30 in the ceilings. And they require at least an R value of 19 in the floors. Don't need to know these, I wouldn't think. No, you don't need to know these, but just understand there's different minimum construction levels. And R value is how insulation is defined. Still building our house. Now we got to get it heated and cooled. So the most common that we see around here is an HVAC system, which combines heating, ventilation, and air conditioning. That's what HVAC stands for: heating, ventilation, and air conditioning. It's a one and done. You flip the switch for the summer, you flip it back for the winter. North Carolina, we're just coming out of the time of year where we're flipping the switch depending on the time of day. And it was just a few weeks ago, we had to have heat on at night and the AC during the day. So our HVAC system allows us to switch back and forth. It can be electronic, it can be gas, not electronic, fueled by electricity. There we go. It can be gas, natural gas, propane. Solar is becoming a thing. I'll talk a little bit more about that in a second. If we're not using an HVAC system, some other sources, some of these are going to be found in like older homes that we're not using anymore, but we're still showing these older homes. So your central forced warm air. This is what we, pretty much what we see today. We use duct system to push the heat and the cold throughout the house. So your ducts, your fans allow the heat and the cold to get pushed through the house. Gravity warm air, we may see that in an older home. With gravity warm air, there is no duct system. It's a central furnace, and that furnace kind of radiates throughout the house. We don't have duct work. Also in older homes, we might see electric baseboards kind of installed on the baseboard. Turn them on, they radiate heat into the room. They can be heated by space heating systems. So think about kerosene heaters, radiators, those little coil thing you might have in the room. Again, no duct system, they're just generating heat. And then solar heating systems. You may have solar panels installed for just one home. You guys starting to see solar panels pop up on roofs a lot lately, aren't we? So you may have just for that one home to capture the energy of the sun to help heat that one home. We're also seeing solar farms pop up. Those solar farms are capturing energy to heat several homes, have several sources. If we don't have central air, duct air. Then we may also have different units, window units, room units. You may have window AC units. It can get expensive to convert from a window unit to a duct system. So just some different options for older homes. I think most homes being built today have central AC. And then back to the HVAC, how does it all work? A heat pump is what pushes the air to and from, away from the home. So we have the heat on, it's pulling air from the outside, heating it up, pushing it through the home. We reverse that process in the summer when we switch it over to AC. It leaves the air cool. I'd say the heat pump and the HVAC is what we see most often, most common in North Carolina. For new construction. Again, if you have an 100-year-old home, an 80-year-old home, you're not going to find a HVAC unit. So just be aware of the different styles. Heat is measured in BTUs, British thermal units. So BTUs are stated in thousands. And how much heat the system can generate is going to determine on the BTUs. A lot of new construction, 2-story homes, what we're seeing is a dual heating system, a dual system. So you might have a system on the first floor and then a smaller system on the second floor. We all know heat rises, right? So if you have a 2-story home with just one unit, it's working awfully hard to cool the second story. So now if we build them with 2 units, one on the first floor, one on the second, then we can regulate those units better and have less stress on the heating systems. If you're showing a home that has 2 systems, all you need to do is walk out back, you'll see 2 units. And the other thing you'll see inside is 2 different thermostats. A thermostat for the first floor and a thermostat for the second floor. Help regulate that. Saves on the energy bill. And then with basic construction, we introduced you to the North Carolina Uniform Residential Building Code back in Unit 6. Remember, those building codes just set the minimum construction standards for safety. So when builders build, they have to follow these residential building codes that do and can change, but they have to be built, minimum construction. And again, the primary intent, the primary focus is safety. Homes under HUD, if you're going for an FHA or a VA loan, for example, may have different standards. So remember, not all properties are going to qualify for an FHA or a VA loan because HUD has different standards. And if you're interested in the building world, you may definitely, once you pass this test next week, pass your PSI exam, you may definitely want to look into the contractor licensing, the general contractor, as that fulfills the requirements of the builder. And that gets us through Unit 16 and effectively the material. So those key terms. There's your key point review. And then your student quiz. For those of you here, I appreciate your time. I'd rather talk to you guys than stand here and talk to myself, although I could, because I do talk to myself on a regular basis, but thank you guys for sticking around. I hope this was helpful. Again, this is going to help you getting ready for that state exam. We already covered the material for your exam next Tuesday. Fair enough? You guys have any questions, let me know. Thank you guys. If you have any questions, let me know. I'm around all weekend. I hope you guys have a great weekend. Best of luck to you guys on Tuesday. Like I said, we'll see you in post licensing soon. Thank you.